All right, let's get started. Let me tell you the order of what's going to happen here. We're going to start with the confidential section first, and that's for purely administrative reasons. By doing it that way, once we're past confidentiality, we can have our court reporter do his thing and have our turn on YouTube, and then admit anybody into the room who can come in as an observer. I think at this point, though, any individuals who are disallowed from participating in the confidential portion of this rate case would have to leave. If there's anybody who's in that category, please do so right now. And also, before we get into this, I just want to state something. It is that it is not acceptable to ask the same question over and over and over again. A slight microscopic change to the question and a re-asking is not a new question. So let's try now and in the future to avoid that. And also, if you're a witness, either this witness or any other witness, listen to the question very carefully. For example, if you've been asked a question, if you're aware that there's a prohibition in the law to do this or that, then answer that. And then, of course, you can go forward and explain and expand what your opinion is on that matter. So those are the rules, and for the rest of the, well, really, they were the rules to begin with, but that's what I'm going to try to be a little more Teutonic about enforcing. So with that, we were in cross-examination of MEA, and we are going to go to the confidential material that's in the
And I think we need to adjust the commission's computer.
You know what?
No, we're good.
Take whatever time you
Okay.
need to do.
Or you can move it if you want.
Oh, no, I think we need to, I was told to take down the sign that says confidential session.
Okay.
We don't need to do that?
It's okay.
That's perfect.
We'll go off the record for a second.
Okay. Take your time, get it done right. All right, we're back on, I believe, and just to again reiterate, the witness is still under oath, and the floor goes to Counsel for McKenzie.
Thank you, Mr. Chairman. We just have one question, but we've actually been able to stipulate with Pepco Counsel that with the introduction of a public data request response by Pepco to 2615A, we would like to move that into the record. It is a response that was sponsored by Mr. Allo, and with that admission, we would be able to conclude our cross-examination of Mr. Allo.
So I just want to be clear. On A, we say, please see the electronic-only attachment, and it's my understanding that's public, and MEA wants to put that electronic attachment into the record, and we do not object. Is that correct, Ms. Moody?
That's correct. We would like to move it into the evidence as MEA Exhibit 2.
And right now they,
We have the.
oh, you have the copies. Could, that's fine.
All right, without objection, so marked and admitted.
I just need the copy.
Sure.
Yes, she is retrieving it.
And if you could give a copy to my witness, I'd,
Yeah, we have 25. Okay, thank you.
I got it.
Thank you.
thank you.
Phone's working now, okay.
So now you can use your inside voice.
Yes. No speaking from the diaphragm.
No,
That was,
I had a friend.
Yeah.
Be confidential.
Did he rule that it's admitted into Mr. Chairman, just
Yes,
want to
Counselor.
confirm that MEA Exhibit 2 has been admitted into evidence?
yes.
Thank you.
Yes,
I
absolutely.
have no further questions.
I think we need some more,
No,
oh, well, here, I think you guys are gonna have to, is that two of them? Okay. All right.
And Your Honor, and I know we've got it into evidence, can I just make sure I'm checking with my folks that it's not confidential? It's not marked as confidential here, but Mr. Allo just asked me about that, and we just need to check. It can go into the record right now. We may have to make it confidential.
Okay, we retrieved it from the Pepco SharePoint under the public data request file.
I understand
But
that.
feel free to double check.
I understand that.
Okay. So is your cross concluded?
Yes.
Thank you very much. We will then, I have to say it, is Montgomery County in the house? Apparently not. So we will proceed to staff.
Thank you, Your Honor. Harrison Scher on behalf of Commission's technical staff, spelled S-C-H-E-R-R. Good morning, Mr. Allo. How are you?
Good morning. I'm doing well. And yourself?
Doing good, thanks. Do you have with you a copy of Staff Exhibit 3 with you, consisting of Pepco responses to staff data requests?
No.
Thank you. Thank you. I have it.
Could you please turn to Pepco's response to DR 56-1? Looks like they have it. Do you want me to ask?
I only see a DR 56-2.
I don't see it either.
He doesn't have it. It should be the second to last page of the packet.
It's 56-2.
Could you give me give me a new one? Because I don't see it in this copy.
Next to the last page.
Here, Fran, look. I don't have it. I don't know why.
Thank you.
If he's just putting him in,
But this, sorry, maybe I'm misunderstanding. I think this is 56-2.
okay.
We were actually,
It should be staff 56, question number 1. May I approach?
It's not there.
Yeah.
This one.
It's fine. I trust people.
Okay, thank you.
Okay. The response to question 56-1 named you as a co-sponsor, correct?
Yes, it does.
And this response discusses 69 kV cable replacement. Could you please read the name of the project listed under DR 56-1A?
ITN 77475.
The full name, please.
So the full name in the question? In
Yes.
A? Okay. Damage equipment replace DC.
Do Pepco DC and Pepco Maryland each have underground 69 kV cables such as described in ITN 77475?
I believe it does.
Could you please read the first sentence of the response to DR 56A, which describes the project?
ITN 77475 reflects with 69 kV aged self-contained fluid-filled SCFF underground cables that are found to be defective and require emergency replacement, as shown in column D of tab plant cuttings, October 2024 to September 2025 in the reference file. The plant closing presented sub-transmission assets, which are allocated between Maryland and DC.
Thank you. That's good there. Just the first sentence. Please explain why Pepco's project description for ITN 77475 does not mention Maryland.
Yeah, I think witness Lemon spoke to that during his testimony and indicated that maybe there is an opportunity not to maybe include the maybe jurisdictional names in the title, because I see that could, create some confusion. But I think your question is going to allocation, and I think Colonel Nelson or witness Lemon is probably best positioned to answer those questions.
But you are listed as a co-sponsor for this question, correct?
Yes, I am, and I can speak to the technical nature of the project and the business justification in relation to the project, but can't really speak to how the costs are allocated across jurisdictions.
Okay. Well, can I ask you, based on the project name and description, Are you able to explain how the commission can determine this project if it's applicable to Maryland's Pepco Maryland customers?
Based on the name, I don't think the commission can understand or decide where it applies.
Could you please, in the answer to 56A, read the sentence on line 3 that begins with the plant closings?
Say that again.
In the response to 56A, could you read the portion of the response that begins with the plant closings?
56(1)(a). Okay. Okay. The plant closings presented are sub-transmission assets which are allocated between Maryland and the District of Columbia, consistent with long-standing commission precedent, as explained in Company Witness Lemon's direct testimony, Part 2.
Thank you. Thank you. How does Pepco determine to categorize capital projects such as sub-transmission assets?
I'm going to object. This witness is not the witness that sponsored that portion of the data request. That's why we have witnesses Nelson and Lemming on here. And he said it in response that those are the right witnesses to ask about the allocation issue.
Yeah, that seems to make it sustained.
Okay. I'd now like you to look at Part B of the question. Could you read the name of the project for Part B of DR 56?
Your Honor, I am willing to stipulate that on all of these projects, the name ends in DC and does not mention Maryland, if that moves things along.
Does that work for you?
I mean, that is kind of the point I was trying to make, is that all these projects are named DC, and it's kind of difficult for the commission to distinguish how it's allocated between Maryland and DC.
And Mr. McKeel, you're basically saying that witness Nelson would be able to satisfy an answer for staff?
Well, he may be able to talk to the allocation and why the allocation is there. I'm just saying the DR is clear that it doesn't mention Maryland in the title, and so I'm willing to say that's true for all three of these.
Right, but you're saying that witness Nelson will be able to clarify this to the satisfaction of staff?
Right, or they could look at the direct testimony of Mr. Lemming that is cited there that talks specifically about the allocation and the commission's longstanding precedent on that for the 69 kV sub-transmission system. That's right in the answer.
Okay, I'll, based on your statement that witness Nelson will be able to answer this to the satisfaction of staff, I'll sustain your objection.
One moment, please.
Take your time.
Nothing further from staff. Thank you. Would just like to request that staff Exhibit 3 be entered into evidence in regards to answers provided by witness Allett.
I mean, I think this has already been, maybe, without objection, so entered.
I just have a point of clarification. So 56-1 was not in the packet. So is that coming in separately?
It was in the first packet. It must have got.
It was in the first,
Oh, okay.
the one with the,
Still don't
which,
have it, but as long as 56-1 is in the record.
the one
website.
which happens to have all the purple tabs. Redirect?
Yes, Your Honor. Staff was just asking you some questions about the 69 kV sub-transmission. Do you recall those questions?
Yes, I do.
From an operational perspective, do both DC and Maryland benefit from that system, if you know?
Yes, it does.
I have some questions from yesterday. Counsel for AOBA asked you some questions. Do you recall the AOBA counsel asking you questions regarding all costs from whether or not all costs incurred for the past years for White Flint are in the record? Do you recall those questions?
Yes, I do.
If you know, Mr. Allo, did AOBA ask Pepco a data request seeking that information?
Not that I'm aware of.
Okay. Counsel for MEA asked you numerous questions yesterday. I'd like to focus on that. Do you recall you got numerous questions from MEA about whether or not Pepco conducted a formal benefit analysis for alternatives at White Flint?
Yes, I recall.
Sir, do you have a copy of your direct testimony with you?
Yes, I do.
Could I ask you to turn to your direct schedule TOA number 2?
I'm there.
And just, it is confidential, so I don't want, I can do, I think, all of these questions in public session, but I just want to tell the witness that these are confidential.
Understood.
Okay. Could you, sir, turn to page, let's see, 23 of 528 in Schedule TOA2, confidential? Or, let me go back. Could you turn to page 1 of 508?
Yep, I'm there.
And is that the White Flint Substation Project PCC deck, sir?
Yes, it is.
Okay. Now can you turn to page 23 of 528?
I'm there.
And let me just ask you this. Does that page indicate that Pepco considered and identified customer benefits related to the White Flint substation?
Yes, it does.
And if you know, Mr. Allo, did Mr. Balakumar refute those customer benefits in either his direct or surrebuttal testimony?
No, he didn't.
Sir, could you turn to page 25 of 508 in that same PCC deck?
I'm there.
Did Pepco consider and identify environmental benefits on page 27 of 508 related to the White Flint substation?
Yes, it did.
Did Mr. Balakumar, if you know, did Mr. Balakumar in his direct or surrebuttal testimony refute any of those environmental benefits?
No, he did not.
Could you turn, sir, to page 27 of 508? Did Pepco consider and identify on that page alternatives to the White Flint substation?
Yes, it does.
And if you know, sir, do Pepco engineers, as part of the development process, look at a number of different options and narrow those options to the most optimal long-term option that will solve the problem identified?
Yes, we do.
And after considering all of those options for solving the persistent forecasted overload at Park Lawn substation, do you know if Pepco picked the optimal option?
Yes.
Objection, Your Honor. This line of questioning is going to what Pepco considered. We asked yesterday if a formal study was done, and he said no. So this goes beyond the scope of what was asked yesterday.
I disagree. I think I'm able to ask what the formal options were and what the informal options were. He answered that there was informal review. I think it's directly relevant to what we did.
I think I agree with you. I agree with you.
Do these pages that I talked about indicate that Pepco considered both benefits and costs?
Yes, it does.
Is consideration, if you know, is the consideration of benefits and costs different from a full-blown cost-benefit analysis?
Yes, it is.
Was the benefit identified by Pepco for building the White Flint substation, relieving the park lawn, forecasted persistent overload, and providing reliable load for the White Flint area?
Yes, it was.
And is that set out in this document?
Yes, it is.
Do you recall questions from MEA Council about Pepco's sister company, Commonwealth Edison in Chicago, and the fact that Commonwealth Edison has a formal NWA screening process?
Yes, I do.
Sir, do you have your rebuttal testimony up there with you?
Yes, I do.
Could I ask you, sir, to turn to Schedule TOAR1, page 15 of 106, and let me know when you are there, sir.
This is TOAR1.
Yes, TOA-R-1, page 15 of 106.
I'm there.
Is that document that was produced in response to MEA data request 6-1?
Yes, it is.
Does that indicate that PHI now has in place non-wires solutions evaluation processes?
Yes, it does.
And if you know, sir, when did Pepco put that in place?
2025, I believe.
And Mr. Allo, did Mr. Balakumar in either his sir rebuttal testimony, did he acknowledge the fact that PHI now has in place a non-wire solution evaluation guideline, if you know?
Yes, he did.
Okay. MEA Council asked you several questions about the topic of hourly load forecasting. Do you recall those questions?
Yes, I do.
While hourly load forecasting may be more granular, if you know, does that mean that the hourly load forecasting is better for purposes of solving a forecasted persistent substation overload?
No, it's not.
And why is that?
It's the granularity gives a false sense of security that it can predict exactly the nature of the overload. And when sizing a solution for firm overload in a substation, like I alluded to yesterday, any overload is detriment to the assets and could cause issues for the other customers served by that particular asset. And as a result of that, regardless of the duration of the overload, there has to be a solution put in place to address the overload.
So if you know, from a modeling perspective, is it important that the load forecast provides insights to the engineer that such an
Objection, Your Honor. These questions are going beyond the scope of what we asked. This is just trying to create another live rejoinder.
Go ahead and complete the question, and then I'll rule. And please don't answer until I give you permission.
Okay.
And may I speak to the objection before you rule?
Of course.
Okay.
Do me a favor.
Question.
No. Do me a favor and start the question once again.
Yes, sir. If you know, Mr. Allo, from a modeling perspective, is it important that the load forecast provides insights to the engineer that such event may happen, but whether it occurs on June 6th or July 7th is not important for the analysis?
That's your question.
Yes.
Okay, so tell me the basis of your objection.
I believe this is going beyond the scope of the questions I asked and the answers I received. This is just trying to create new live rejoinder to go beyond that scope of what was asked.
This question is directed specifically at the questions from MEA Council about whether or not it's appropriate to do an 8760 hourly load forecast and whether that matters or not with respect to building the White Flint substation. It's directly on point.
Mr. Allo directly responded to that question and said whether it's 1 hour or 8,760 hours, it doesn't matter. They would have still built the substation. So now expanding on that is going beyond what is needed on redirect.
Well, it's a close call, but I think that his response to you yesterday allows the counsel for the company to ask the question, so the objection is overruled. It's a close call, though, in my mind. So you can answer the question.
Can you please repeat the question?
Yes. Third time is going to be a charm here, I hope. If you know from a modeling perspective, is it important that the load forecast provides insights to the engineer that such an event may happen, but whether that event occurs on June 6th or July 7th is not important?
That is correct.
Assuming counsel for MEA asked you some questions about whether or not a battery could solve the problem at the overload problem at Park Lawn yesterday. Do you recall those questions?
Yes, I do.
Assuming a battery was a viable solution to the overload, making that assumption, would an hourly constraint analysis be needed to size the capacity of the battery properly?
Can you restate that question, please?
Yes. If we assume, that's not our position, if we assume that a battery was a viable solution to an overload, would an hourly constraint analysis be needed to size the capacity of the battery?
I wouldn't say it's needed, but it's a tool that can be used to size the capacity of the battery if the battery was going to address the problem statement of the increasing persistent overload at the White Flint area.
If a battery was not a viable solution to solve the persistent increasing overload at the Park Lawn substation, would an hourly constraint analysis be needed?
No, it wouldn't.
I want to ask you just a couple of questions about what's been admitted into the record as MEA DR1, the data request. Do you have that, sir? I know you've got a lot of paper up there. No, it's the data request with the load forecasts attached.
Okay, small one. Okay.
I know it.
Yep, I have it.
Okay. Do you recall those questions, sir?
Yes, I do.
If you know, does Pepco's peak load forecasting process by design provide a 90% load forecast based on year-to-year changes and variations, such as weather?
Yes, it does.
Why is that methodology used?
Objection, Your Honor. This is really going beyond the scope. I didn't even get to ask a question about that exhibit, and this is really a live rejoinder at this point.
Repeat the question for me.
Yes. If you know, does Pepco's peak load forecasting process by design provide a 90% load forecast based on year-to-year changes and variations, such as weather? He said yes, and then I asked, why is that methodology used?
Another close one, but in this case, I'm going to sustain the objection.
The reason that is
The objection's
can't-
been sustained.
You can't.
sorry.
You can't.
So
Sorry.
you have to not answer, sir. I'm so sorry.
No. I just This all legal thing is new to me, so I apologize.
Like, if you just give me 1 second here.
Yep.
Your Honors, I'm finished. Thank you for indulging me.
Not at all. So we will go to questions from the bench in the following order: Suchman, Hoover, McLean, Linton, and then the chair. Commissioner Suchman.
Good morning again, Mr.
Good
Oliver.
morning.
My questions are going to be focused exclusively on White Flint because I feel like we haven't had enough conversation about White Flint. Based on testimony yesterday, it sounded like White Flint was actually in discussion around 2011. So it's been a while that you've been looking at White Flint as a way to address the park lawn
Correct.
constraints. And then we had a conversation. Several people had a conversation about the commission's order in 9655.
That is correct.
And so that was Order 89868, which you reference in your testimony and your rebuttal. And in that order, as you've sort of been able to discuss with other parties, the commission said that they would not permit you to recover, to pre-approve the recovery of those costs, future costs.
Correct.
Although they would permit you to recover what had already been incurred. Do you have a sense of how much of what Pepco had done up to that point and how much you spent in terms of the White Flint substation project?
No, I don't know the exact numbers, but I believe the company is gathering that information based on your bench request.
Okay. And in the order, the commission gave reasons for the fact that it wasn't sufficiently comfortable or had sufficient confidence in your load forecasting, consideration of alternatives, and cost benefit analysis.
To approve for the MYP.
For the MYP, right. And then you mentioned in your rebuttal that you then postponed for 2 years. And in that period, was any work done on White Flint substation?
No,
Okay. So during that 2-year period, that's when you hired Quanta to do the analysis?
yes, to do a load study.
Okay. Was there anything else that you did during that 2-year period?
No, just the load study.
Okay. And then you looked at the load study and it confirmed what you had. So you had also done a load study internally.
Correct.
Okay. I'm assuming that if Quanta had done a load study that gave different information that there was not a problem, then you would not have proceeded with the White Flint substation.
That is correct.
project. Okay. So you resumed construction when?
In 2023.
The end of 2023?
Correct.
Okay. And had anything changed in terms of the projects that you had been the projects that were causing you to need to build out the White Flint substation? Had anything changed in Maryland in terms of the entities that you were sort of building your station out for?
No, so part of what the Quanta study did was vet the load request that we had
Okay.
and confirm that that was there. In addition to that, they leveraged or added the perspective on electrification at the time, the growing building and transportation electrification within the area. And they also applied the Montgomery County changes requiring that all buildings beyond, I think, 2026 had to be built with 100% electrification. And leveraging those data points, ascertained and confirmed that the forecasted overload of Parkland was still the situation.
Okay, so let's turn to your rebuttal testimony, TOA R-1, page 71.
71 of
Right, so
106?
this is a response to OPC data request 5-3.
Sorry, 71 of 106?
Yeah, 71 of 106.
I'm there.
Okay. And the request under C was to provide a breakdown of the specific customer developments driving the load growth in the specific area.
Yep.
And then you list 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 customer developments that were driving load growth.
Correct.
Okay. So, and these were, when in your response to my previous question, so nothing had changed. These were all projects that you've identified as being committed to moving forward.
This was the latest information that was available in 2025 when we received this data request.
Okay.
I think the Quanta study lists projects that were the projects, and some of them do overlap, but it does have a separate list that lists the projects that were confirmed back in 2023.
Okay. So of these projects, anything that was new, based on the Quanta analysis?
I'll have to compare this to that to tell which is new.
Okay.
But this is just the snapshot from when the data request was received.
Okay. For the Metro MC bus garage, what is that? Is that the build out of the
I think it's a Montgomery County bus garage, and it's one that is meant to have a lot of electric buses. And the request we got is for 18 megawatts capacity request.
Okay, and is that project moving along?
As far as I know, yes.
Okay, and then the White Flint Mall redevelopment.
Correct.
I guess this is I already know the answer to this question, but is that moving along?
You probably know better than I do.
Yeah, I think the answer is no. So, I
2025.
yeah, I see it all the time. So, in terms of these entities, do you engage with them directly?
My team does, correct.
Your team does?
Yes.
Okay. So have you had conversations with any of them about ways to reduce their demand on the system, renewables, energy efficiency, even microgrids? Have you had those conversations with any of these entities?
We do not provide consulting services for them, no.
Okay. Anybody had a conversation encouraging them to look at these opportunities? I mean, this is, accommodating these, very large loads coming in. It would be a benefit to the system if they were to do things that could help, as opposed to sort of taking from the system. And your people didn't have any conversations with them about.
No.
Okay. When you have conversations with large developers, when do you think it's appropriate to seek contribution in aid of construction?
When the assets they're acquiring only serves them. So if a particular customer is coming on board requesting 10 megawatts, maybe requiring 8K VA transformer, they would be required to pay specifically for that transformer. If the distribution line that is going to be built to serve that transformer is going to be used by other customers, then that customer is not going to be paid for that distribution line that serves the transformer.
Okay, so if we were to just take everybody out of this list, other than Metro MC Bus Garage, and if they're the only entity that comes to you and says, we want to build out this, and you say to them, well, we really can't accommodate you unless we add to our substation. At that point, you would seek kayak from them.
So we have an obligation to serve every customer that requests service. If they were to require capacity for just their facility, that particular charge would be, they would have to pay for the 100% of that charge. Now, if their capacity triggers a broader need, so substation 80 MVA capacity typically serves multiple loads. If for some reason their particular request is the one that triggers the need, and they're only going to be using a certain portion of that capacity, they wouldn't have to pay for it because the broader society benefits from that capacity that is built in, even though they're the ones that needs a portion of that capacity. That's currently the way the tariff is applied.
Okay, but let's say the Metro bus garage needed 100 megawatts.
Correct.
And so would really have had to, you'd have to build out substation to accommodate them.
Yep.
Would you assign 100% of the build out to them?
If they require 100 megawatts and the size of the equipment that is being built is 100 megawatts, then yes, they would have to pay 100% of that cost.
Okay, but and then if they only needed 20% of what you build out, would you assign 20% of the cost, or you would still? So it's either 100 or nothing.
Yes, it's if the asset is going to be used by other members of the society, then they would have to pay for only the portion that is directly allocated or directly required for their service, but not the broader base. So for the transformer assets, 100 megawatts, they require 20 megawatts. That 100 megawatts substation or transformer that is built would be socialized across the customer base, and you wouldn't ask them to pay 20% of the cost of the 100 megawatts.
Okay, but if they needed all 100, then you
Then they
would
would pay.
Okay, and then if you took these 12, if these 12 entities are the driver for the White Flint substation,
Yep.
and nobody else is a driver,
Yep.
you're still going to socialize the cost of that to the entire community.
If the 20 did you say 20 customers?
Well, it's 12.
Yeah, if the 12 customers are in the same customer class, then there's possible to create a type of rate structure that they pay for that particular asset. But if you look across this, it's it's buildings, malls, hospitals, residential communities. You would not charge them for the cost of the asset. It would be socialized across the customer base if other customers can use that particular asset. If for example, we built it and they pay for it, then we can't use that asset for anything else. We can't, like, any new development that comes in Montgomery County cannot use that particular asset. You'd have to build something completely different for them if they were to pay for 100% of that particular asset.
Well, I mean, the concern I have is that there 12 entities are driving the cost for building out White Flint, and yet everybody is paying for it. And I'm just wondering if Pepco thought about another way of assigning cost responsibility that didn't involve raising rates for people who are already struggling to pay. I mean, this seems like it's a cost of doing business for them, and yet you've made the decision that you're going to socialize all of the build out along 355 to the residential customers. And I'm just wondering if there's just some other way of addressing this without raising the rates of customers that really can't afford to pay for it now.
Yeah, and I think, we didn't make the decision. I think we applied the regulatory framework within which we work under to make that allocation. And, I'm sure we can have broader conversations on other structures where that could be possible. But as far as I know, under the current regulatory structure, we didn't have the option to do that.
Well, and certainly having the conversation with them about ways to reduce the kind of demand that they're going to put on the system seems, I mean, you're involved in a number of our proceedings that are looking for non-wires alternatives, and this is like sort of the ultimate non-wires alternative, which is to make sure that you have a customer that's not imposing the demand that they would have done 10, 20 years ago when there weren't opportunities for all these other technologies to reduce their load. So that's all I have. Thank you.
Thank you.
Commissioner Hoover.
So if the economic development projects that have been talked about, Witness Lemming yesterday mentioned some new customers that he was expecting to come to take service from the White Flint station, and then as part of your testimony, you introduced the press releases about the new medical facilities. If none of those things occur, is it still necessary to build the White Flint station because of the demands of the current customers that you serve?
No, so the forecast would grow like every other area across Pepco, and the Parkland substation would have been sufficient to handle the load. I think the redevelopment in Montgomery County is driving a lot of changes, basically taking low-rise buildings and making them high-rise buildings, and this type of change, which is similar to what happened in Mount Vernon and some other areas in the Pepco territory, is what's driving the need for White Flint substation and triggered the overload in Parkland substation. So you are correct that without this redevelopment and without the multiple requests for service by developers in this area, we would not need to build a new substation in the area at this time.
Okay, thanks.
You're welcome.
Commissioner McLean.
Thank you, sir. Good morning, sir.
Good morning.
I had a couple of questions. Your counsel was asking about battery storage.
Correct.
And there is a question and answer in MEA's cert rebuttal where Mr. Balakumar's question, the question is, Pepco's response to MEA data request 7-6 states that a storage solution would have needed to address greater than 20 megawatts in peak demand. And what is your response to that claim? And I'm looking at page 25
Yeah, please.
for anyone scoring at home.
Page what?
25 of Mr. Balakumar's survey. Oh, my
No
apologies.
worries, no worries.
Why don't you go ahead?
Okay, page 25.
Yes, sir. The question's on page 2, line 2,
Okay.
sir?
Yep.
Okay, and then Mr. Balakumar goes on to say that your response states that a storage solution would have been needed to address greater than 20 megawatts in peak demand.
Yep.
And his question was, where did that come from?
Okay.
Where did that figure come from? And if you said it yesterday, I apologize.
No, I did not say yesterday.
Okay, good.
Thanks for the question. I was hoping I'd get the opportunity to kind of explain it in more detail. So,
It's code for asking all stupid questions, but go ahead.
No, it's a great question. So when you think about the forecast, and when I say the forecast is increasing, is persistent and increasing, the increasing nature is the overload that goes from year to year. In the first year of the forecast, there is an overload of about 1.3 megawatts. By the fourth year, the overload is about 10 megawatts. If you're sizing a battery capacity to support 10 megawatts, what you would do is understand three things. The first is batteries are not 100% efficient, so you don't get one for one. So you need to upsize it a little bit, right? Everyone that has an electric vehicle understand that you don't use your battery to 0% from 100% to 0%. There is a certain margin you have to keep. Manufacturers recommend that you only operate between 80% to 20% of the battery. You apply that to this particular scenario. By the time you apply the multiple derating and you apply the hourly constraint analysis, you'd realize that you need, quote unquote, instead of a 10 megawatt overload in 2024, you would need about 15 megawatts. Now, if you need a 4-hour capacity on 15 megawatts, you'd need about a 60 megawatt hour battery, right? Mr. Balakumar did some analysis and indicated that 48 megawatts battery was about $32 million. That's drastically inaccurate. He uses the land prices in Baltimore to simulate what the land prices would be in Montgomery County. And anyone that lives in Maryland know that the prices are about 3 times the price. Yes, it doesn't take into account any distribution cost to serve the multiple battery locations that he assumes. I would propose that the estimate would not be 32 million, it would be more about 50, 60 million dollars. Now, when making a decision as to the right solution to address the increasing overloads, we are looking at a situation where in 4 years, the solution is not going to be valid anymore. We're also looking at the reality that states that it takes over 4 years to build a substation. So at the time you're starting to build the battery solution, you are spending the same amount of money to build the substation. So a customer will be paying not just the cost of the battery, but will be paying the battery and the substation cost. And that's why the company deemed it imprudent to actually invest in the non-wires alternative solution for this particular problem statement. This is upon the fact that back in 2017, 2019, this was not a contemporary solution. It was a highly risky solution that had its risk, as was demonstrated by the articles that we provided of the Warwick experience. They've had 2 fires that have turned the substation capacity a lot less than they expected it to be. Granted, those are learnings that anyone could not have predicted. I wished that that didn't happen because obviously it puts a negative frame on the entire industry, but that was the risk that they took on. If the load was growing, to Commissioner Hoover's point, at like a 1-2%, let's say we didn't have this big loads, this redevelopments coming on, and it was just growing at about 1-2% rate every year, then it's a ripe candidate for a non-wires alternative solution. But the fact that we want to do a non-wires alternative solution doesn't mean it applies everywhere, and in this particular scenario, it didn't apply.
All right, thank you for that. Let's see, I got a couple more for you, sir. Do you happen to have OPC, Mr. Fitzhenry's SIR rebuttal in front of you, sir?
No, I don't.
I have a copy
Okay.
for him.
And I also have an AOBA question, if that, if that just to
All right.
help you out, Mr. Mike Keel. All right, if you could go to page 15, sir, of Mr. Fitzhenry's SIR rebuttal. You there, sir?
Yes, I'm there.
Okay, on line 17, he states over the next 10 years, the combined utilization ratio for the park lawn and White Flint study area is forecasted to peak at only
35.8.
Yeah, sorry. Yeah, percent. And
Yep.
then he does his math. That 35.8%, does that include all of the projects you just talked about with Commissioner Suchman on in your schedule?
So a couple of things. So he's using actual numbers.
Right.
So he's not.
And I know
he's-
you
yeah,
don't
so-
necessarily agree with
yeah,
that position.
No, but not even just that I don't agree with the position. It's that he's basing his numbers based on actuals today. So without any of this load forecast showing up, he's also basing his numbers on utilization factors during a normal operating conditions. And like I alluded to earlier, when we build and plan a forecast for a particular area, we are simulating the worst case scenario and comparing the utilization factor normally to what is today for an asset that is going to be in 50 years will always result to this type of normalization. In fact, if you apply this same rationale to any capacity substation project, you would find a similar utilization in the early years of the asset's energization.
Okay, so the 35.8%, that's actual, but does that
Correct.
include any of the projects you discussed?
No, it doesn't.
Okay, so, okay. All right,
It's like actuals as of like today.
sure. All right, okay, thank you. All right. I've got one more question for you, and I don't know if we've talked about this or not.
AOBA or AOBA?
AOBA, sir, yeah, it's Mr. Oliver's SIR rebuttal on page 7, sir. And if Mr. Nelson's the more appropriate witness, just let me know. At the top of page 7, he's has a concern about this major storm event in 2023.
Yep.
And his position is that it's essentially 2 separate storms rather than, I guess, one big one.
Yep.
Uh,
Yeah.
Can you respond to that,
Yeah,
sir?
I disagree to him. We classify these events as major outage events, and just because the storm has different waves doesn't change the fact that it's one event. And in this instance, it was one day we opened the storm center, the team mobilized and we're working the storm. While responding to the actual outages from the first wave of the storm, a second wave came through the next day. The storm center was still open. The event was still ongoing. We hadn't lowered the storm flag, closed down the storm room before the second event occurred. And so our position is that it's one storm as opposed to two storms.
Okay, even though it's, technically it was two storms. I know you said
Yeah,
different
yeah.
event or phase,
Yeah.
but okay. Okay, thank you very much, sir. That's all I have.
Commissioner Lynch?
Thank you, Mr. Chairman. I had a whole host of White Flint questions, but those have all been asked already. So we'll talk instead about the Smart Fault Sensors program,
Okay?
which it's always been fascinating to me when we have a pilot inside of a pilot. You know, it's like trying to draw a four-dimensional shape on a two-dimensional piece of paper, but you know, that's pretty nerdy, so I won't go into it anymore. But Staff Witness Lowe, in his direct answer rebuttal, after reviewing your rebuttal, still recommended disallowance of all of the costs for that program until the company could demonstrate that it has actually been valuable and is actually working.
Yeah.
I guess I wanted to make sure I understood what the status of the program was now. But before I get to that, are you still, I know there's been some updates of testimony, are you still requesting recovery of those costs?
Yes, we are.
Okay. So help me to understand what the status of the program is now. Just for example, according to the information I saw in the testimony, it looked like about 85% of the funding was primarily administrative costs, and the smaller number, the remaining, was related to the actual mechanical equipment. What's left? How is it operating from here?
So I mean, and I think my position on staff, respectfully on staff witness Lowe's position is that the recovery of the investment on the pilot should not be tied to the success of the pilot. The pilot is meant to gather lessons and learnings, and even the pilot's failing means the pilot was successful, because it tells us what we shouldn't do, and we can take that learnings and apply it in a broader scope. And so that's why my position was that I still think it's a valid request to be recovered on. The status of the pilot is still ongoing. The intent of the pilot is to install fault sensors and be able to have highly accurate prediction and location of fault, which was meant to improve visibility across the system and improve our ability to respond to fault on the systems. Many times, locating and know where the fault is as quickly as possible gets us saves us time and basically reduces the duration of outages. And so this was a pilot based on industry conversation that we thought would be helpful for us to do, and we are currently engaged in doing that. The equipment is part of the cost of the pilot, but in addition to that, there's also the time and resources that it's going to take to actually study those pilots, write a white paper, evaluate the pros and cons of those pilots, and then make a recommendation. And so I think the cost that is within the window of this test year was meant to enable communication on the particular pilot. We had installed the devices. We've now enabled communications, and we're currently in the monitoring phase of that pilot and looking to publish the results of the pilot experiences and make a recommendation on if we should continue to move forward with this technology or not.
Okay, so in your rebuttal testimony, I believe that's where it was on page 60 of your rebuttal. I believe in that, and there's several pages afterwards. I believe there the company acknowledged that it looked to have the pilot continue and perhaps even expand it. Is that intention to see something further with this pilot built into the reasoning for continuing the pilot right now, even though the period of time that was initially thought of as this pilot operating has elapsed?
No, so we wouldn't continue to expand the pilot without concluding the pilot and making a recommendation on whether to proceed or not to proceed.
So how does it conclude?
It's scheduled to conclude this year, and the intent is it's going to conclude with a paper indicating what our recommendation is based on the pilot that is done.
So are there additional costs that you need in order to conclude it this year, or are you just looking to recover the costs that were part of the initial pilot from, I guess, what was it, 3 years ago? Or
Yes,
3 years
so-
from the time?
I think what we're looking to recover is the communication cost that was spent within the test window that we're seeking recovery for.
And the administrative, everything, the administrative cost
Correct.
as well?
Yes,
Okay.
correct.
Okay. All right. Thank you.
Thank you.
Mr. Chairman.
Thank you. I have a couple of questions. Before I get into them, I just want to fundamentally understand the physical mechanics of substations. Do they serve discrete territorial areas, or is there overlap between these substations? How does that work?
So there is overlap. There is meant to be operational flexibility so that if one station loses supply, you're able to pick as much load as possible from that other station using feeders. And so we try to create overlap when we build substation assets.
Okay. I looked at the list of the projects that worked into your load forecast, and perhaps you're not the person to answer this. Perhaps another witness will know the answer to this, but I was struck that there was nothing for the Purple Line project, which I imagine uses a lot of electricity. Is that a different substation, or what? Are you?
I'm
Do you know the
probably
answer?
the witness to speak to that, but I don't have that answer handy. But
Okay, well, maybe a future witness will be able to answer that.
I don't think there's any future witness that would be speaking to the technical nature of the project, so I'll probably be the right person to answer it.
Okay.
But I don't know offhand what stations in Montgomery County is feeding the Purple Line project.
We're happy, Your Honor, to get that
Yeah.
information
Well, then I
if
would-
you would like to see it.
I think, yeah, I'm going to ask for that as a bench request,
Okay.
because I think that's important for the commission to have in its mind.
I just want to make sure I get clarity. You want to know what Pepco substations in Montgomery County are impacted by the Purple Line?
Correct.
And I know it's Linden, and because I live by Linden. No, never mind.
Okay,
He knows more than I do.
okay. One of the reasons I asked about the discrete territory of, actually, I think, let me ask you another question. This substation, do you have an actual mapped out territory for it?
Yes and no. It's the lines of the territory is feeders from the substations, and there's going to be overlap between multiple substations, and so I can draw a map, but it changes as operations make changes. Whenever there's a fault, and we need to kind of pick up the customers, we can end up using the different substations to pick up those customers, and so that line, that boundary changes on a daily basis.
Okay, let me explain why I'm going there. I looked at the Quanta report. It's very large, so I didn't look at the whole thing, and you could probably spend weeks just on that alone. The Quanta report was, correct me if I'm wrong, it was published May 9th, 2023. I think that's on the front page of the report.
Correct.
Okay. So let me tell you about a concern that I have. 2 months after the Quanta report, well, obviously the Quanta report is written up to accommodate all of the facts during that study, and I imagine the company probably tied up their analysis somewhere in April of 23, and then they printed it up, wrote it, and printed it up.
Yep.
Let me tell you what I'm very concerned about. 2 months after that, the Montgomery County government implemented one of the strictest rent control laws in the nation. They number their ordinances. It was 15 23. This happened in July 18th of 2023, and I think it went into effect a week or two later. It's a very strict statute, and as a result of it, it's been reported in the press that multi-housing permits have dropped 96% in the Montgomery County portion of the county. The city of Rockville has its own zoning ordinance for that, and they haven't implemented rent control, and same thing with Gaithersburg. But for the vast majority of Montgomery County, that's the law, and it's resulted in a precipitous drop in housing permits. So could it be possible that the Quanta study is partially obsolete as a result of that action 2 weeks later? Could that be possible?
My thoughts is no, it doesn't impact the forecasted load for the White Flint area.
Okay.
I looked into the order you mentioned, and I believe it applies to.
You
I think-
say you looked into
Yeah, I
the
looked into
the
the
law
one you
that
just
Montgomery.
mentioned, yes,
Yeah, okay.
and it goes back. I think it excludes any building that is greater than 23 years old.
Correct.
And not only that, it also doesn't apply to new developments that are coming online. So it's gonna impact. So it's the buildings that existed that were built 23 years ago, but grandfathered is what I understand. And
Well, this is what I understand is that any building that's more than 23 years old is exempted, which means this would apply to new builds. Okay, I don't want to debate the
Yeah.
the
So,
issue,
yeah.
but what I suppose I'm trying to ask is, because this law applies to new builds,
Yeah.
and the entire purpose of the substation is to accommodate new growth, could it be that the Quanta study is partially obsolete as a result of that?
I think the order. It's possible that it's going to impact. I think the reality is it's going to impact the growth in Montgomery County. I think this order was passed after we made the decision, and as a result, probably didn't take the implications of the decision into account when making that decision. But I think I do see your point that it could impact the developments in Montgomery County and probably maybe delay some of this project.
Yeah, I mean, and the reason I asked the question about boundaries of these substations is that obviously this White Flint substation is also going to support the southern part of municipal city of Rockville,
Yeah.
where there is construction.
Yeah.
So I'm just trying to filter out in my mind what the effects of all this is going to be. I mean, I think, you know what, I won't offer an opinion. So I think that's it for my, hold on, wait a minute. Yeah, I asked everything I wanted to ask.
Okay.
Thank you very much, Witness Hollow.
Thank you.
So,
I-
I think time is right for a 10-minute break. So why don't we do that, and you will call up your next, who is your next witness? I'm just, okay. We'll get to him in 10 minutes. And off we go. Back at it. Mr.
Yes, Your
McKeel?
Honor, Pepco would like to call Mr. Suchita to the stand.
And if you could swear him in.
Yes, I do.
Mr. Suchita, would you state and spell your name for the record, sir?
My name is Toshiki, spelled as Toshiki, Bruce, spelled as Bruce, Tsuchida, spelled as Tsuchida.
And Mr. Suchita, can you tell me your educational background, sir?
I've got a bachelor's in mechanical engineering from Waseda University, which is in Tokyo, Japan, and two masters, one in electrical engineering and computer science, the second one in technology and policy, both from the Massachusetts Institute of Technology.
And how are you employed, sir?
I started my career as a utility engineer in Tokyo, and just around the turn of the century, I converted myself into a consultant and been doing consulting ever since for the last 25 years.
And have you caused to be filed what I asked be marked as Pepco Exhibit 19, the rebuttal testimony of Toshiki Bruce Suchida?
Yes.
And does that, sir, rebuttal testimony consist of 14 pages and 2 schedules, sir?
Rebuttal testimony, yes.
Yes, the rebuttal testimony. And that's the only testimony you filed?
For this case, yes.
Right. Do you have any corrections or additions you need to make to that rebuttal testimony, Exhibit 19?
Yes, I do. Line 4 of page 2, there's a slight typo. In the middle of the sentence, it says, "Witness Mr. Bruce R. Oliver, representing behalf of the Apartment and Office Building Association of Metropolitan Washington." I would like to strike out "behalf of," so it reads, "Witness Mr. Bruce R. Oliver, representing the Apartment of Office and Building Association of Metropolitan Washington."
And with those corrections, sir, would your answers be the same or similar today in your rebuttal testimony?
Yes, they would.
Your Honor, with that, I would move the admission of Pepco Exhibit 19, Mr. Suchita's rebuttal testimony.
Without objection, so entered.
And then I would ask leave to do some brief live rejoinder of this witness, Your Honor.
Please proceed.
Mr. Suchita, have you had the opportunity to review those parts of OPC witness Fitzhenry's rebuttal testimony that discussed the study you conducted for Pepco?
Yes, I have.
And focusing on page 3 of that rebuttal testimony, sir. Let me know if you have it.
Yes.
Do you agree or disagree with Mr. Fitzhenry's claim that customer costs must be included to make a cost effectiveness determination?
I disagree.
And why, sir?
First off, my understanding of the study that we performed, the quantitative analysis, was Pepco proactively providing an analysis in response to a commission from the previous case suggesting that Pepco did not quantify the benefits enough. And therefore there is no framework to do so. So what I did was I looked at what other cost-benefit analysis frameworks were, and I give 2 examples of why it talks about the societal benefit as the underlying foundation for all these cost-benefit studies. I further note that witness Balakumar from MEA points to 2 additional studies, one in New York and one in ComMedicine in Chicago, that both look at societal benefits. So with that, I just thought that the societal benefit would be the most appropriate metrics to calculate in the quantitative analysis.
Sir, turning to page 4 of Mr. Fitzhenry's rebuttal testimony, let me know when you're there.
Yes, I'm here.
Do you agree or disagree with Mr. Fitzhenry that the use of a 1% savings rate on diverse assets introduces a high level of uncertainty into the total benefits calculation?
No, I do not. In my rebuttal testimony, I said that even if we exclude the O&M benefits, the total story or the overall story will not change. The benefits that are provided through the O&M saving is very, very minuscule. Furthermore, in the calculation, we calculated the benefits of O&M based on two different vintages of Pepco's cost of service study to be about 1.4%. We shrunk it down to 1%, so there's already quite a significant margin of error included in that 1% on the conservative side. So even if we've done O&M studies for individual studies, and if they all change by 50%, the overall story is not going to change.
Have you had a chance to look at Mr. Fitzhenry's Sir rebuttal testimony on page 5? Do you agree or disagree with Mr. Fitzhenry that the weighted adjusted cost of capital, WACC, is more appropriate than a real discount rate metric for use in your analysis?
No, I do not. And as I said earlier, my understanding is that the societal benefit is the framework that many of the cost-benefit analysis that are performed by others and also suggested by approaches that were developed within Maryland have been using.
Sir, could you look at page 6 of Mr. Fitzhenry's Sir rebuttal testimony?
Yes, I'm here.
Do you agree or disagree with Mr. Fitzhenry that he has identified critical omissions in the Brattle study?
Can you point me to the line that you're looking at, please?
I knew you were going to do that. Let me get the testimony. Sorry. Just bear with me. If you could look, sir, at page 6, lines 2.
Okay, I see that.
Sorry about that. I should have had the line in there.
I don't see any critical omission in the study that we performed. Mr. Fitzhenry points to very minute details. For example, the 1% O&M calculation that he thinks is going to cause a big difference in the results, despite the fact that the total benefits associated with that is very, very minute, and it will not really change the overall story. He also points to why the weighted average cost of capital based evaluation is the proper one without providing any evidence of what's or any examples of such cases. He also, in his direct response to the DR, I think it was number 57, admits that he has not done such an analysis, or he has not observed any other cases where the WACC adjusted metrics were used and thereby was denied or approved by any commission. So I do not agree with what he is saying there.
Now also, sir, on page 6, and let me focus it a little more, lines 5 through 8, are you asking Mr. Fitzhenry to fill gaps or rectify errors?
No, I am not. In my rebuttal testimony, I asked the interveners, including Mr. Fitzhenry, to provide alternative approaches or some evidence to back up their positions. And at least to my understanding, Mr. Fitzhenry has not provided any of that.
Okay. Have you, let me ask you, do you have a copy of Mr. B. Oliver's Sir rebuttal testimony?
Yes, I do.
Have you reviewed Mr. Oliver's testimony regarding the Brattle study?
Yes, I have.
And sir, if you could turn to page 37 of that study.
Yes, I'm here.
37 of that testimony, not study, I apologize. Do you agree or disagree with Mr. Oliver that the Brattle study is a one-year snapshot and that is an incomplete assessment of costs and benefits?
No, I do not. I would like to clarify that Pepco asked me to perform the study so that Pepco can file the study as part of the 2026 rate case. So if I were to include information for other years, it would be confusing. So I purposely limited to the 2026 numbers. But in doing so, for example, if there's a project that requires 3 years investments, I assumed all 3 years investments were made and thereby calculated the benefits afterwards, and then prorated that benefit that was calculated using the investment amounts. So if 2026 investment was 1/3 of the total investment, then 1/3 of the benefits were assumed to be contributed by the 2026 investment. So it's not a one-year study. It did look at the different investment plans overall benefit that may have required multi-years of investments.
Sir, I'd ask you to look at page 38 of Mr. Oliver's rebuttal testimony.
Yes, I'm here.
Do you agree or disagree that the study did not assess benefits for 15 separate investment plans?
The study did look at individual benefits for all 15 investment plans, and we looked at 4 different metrics or 4 different types of benefits. So we did look at all 15 individually, and to the extent that we could, we analyzed them using investment plan or project specific information. Where there were information that were not available. So for example, if you look at project 189069 Pepco Bells Mill Transformer number 11 replacement. What we did here was, because we could not find adequate information for this transformer, we relied on the other 2 transformer replacement projects to figure out what the harm of a failed transformer would do. So where there were not appropriate data, we relied on what we considered to be the second best information, predominantly driven by other projects review.
And I should have done this earlier, just for the record, Mr. Suchida, is the Brattle study attached as TOA3 to Mr. Allo's direct testimony?
Yes.
Looking at page 39 at the bottom, going over to the top of page 40 of Mr. B. Oliver's rebuttal testimony, do you agree or disagree that the study did not use data and analysis sufficiently tied to the actual information, and that using such data is necessary?
I do not agree. To the best of our ability, we used Pepco specific information, such as the outages caused by its equipment or the benefits that a similar project has provided. We also used what's commonly accepted in the industry, a calculator that's called the ICE calculator. It stands for Interruption Cost Estimate Calculator. And specifically within the ICE calculator, we used the Maryland data. So yes, it may not perhaps be Pepco Maryland specific data, but in my mind, looking at Maryland data in the ICE calculator is close enough.
With that, Your Honor, I would tender the witness for cross-examination. Thank you.
All right.
And move the admission of Exhibit 19.
So accepted.
I will have just a couple of questions.
Okay. Floor is yours.
I just need a moment to find something. Mr. Tishida, would you agree with me that on page 5 of 44 of the Brattle study that you have in Schedule TOA-3, you state, I'm going to quote, "For a few investment plans where Pepco could not provide enough data to calculate the benefits, the Brattle Group assumed they would be at the same level as other similar investment plans?"
I'm sorry, page 5?
5.
5 is the page that starts with throughout this report.
I'm sorry?
5 is the page that starts with throughout this report. And I'm apologizing because I have 2 page 5s. This is probably based on our internal.
Well, let me ask you this way, because look at page 38 of Mr. Oliver's rebuttal testimony.
Could you pull the microphone just a little closer?
Okay. Please look at page 38 where you were focused with Mr. McKeel.
I'm here.
Okay. Now, look at the top of the page, and let's just start on line 3. Do you agree that your TOA-3 states, quote, "For a few investment plans where Pepco could not provide enough data to calculate the benefits, the Brattle Group, in brackets, assumed they would be at the same level as other similar investment plans"?
Yes.
Okay. Now, would you also agree that the Brattle Group study examines costs and benefits for only 38,370,000 investments?
Was that the question?
Yes. Would
Yes.
you agree? Okay. And would you also agree that witness Lemming's schedule RTL-3 lists over $900 million of plant additions?
I have not looked at witness Lemming's documents.
So you would not agree? Or
I
you
haven't
don't
looked
know?
at it, so
You
I don't know.
Okay. That's all, Your Honor.
All right. Next, MEA.
No questions, Your Honor.
All right. I still do not see Montgomery County, so People's Counsel.
Thank you, Your Honor. I actually do just have a couple questions prompted by the live rejoinder. I guess, good afternoon, Mr. Sushita.
Good afternoon.
So during a live rejoinder, you stated that you prepared this study to support Pepco's forecasted test year proposal. Is that right?
Yes.
And I think on the first page of the study itself, in the introduction, you state, or the study states that it's Pepco retained the Brattle Group to perform quantitative analysis of the benefits for 15 capital projects and programs scheduled to be put into service in 2026. Is that right?
Yes.
And to your knowledge, this forecasted test year proposal has been withdrawn from the case. Is that correct?
Yes.
Do you recall what time period is reflected in Pepco's traditional test year compliance filing, which is currently under consideration in this proceeding?
No, I do not. However, I have been notified that 2 out of the 15 projects are no longer part of the whole process because of the forward-looking test year issue.
Just so I heard you correct, you said 2 of the projects that you had reviewed are removed?
Yes.
Could you identify those 2 projects?
They are subject to check because this is my scribbling. 69084 Pepco MD Distribution Central Avenue T2 and ITN 189069 Pepco Bells Mill Transformer number 11 replacement.
So to be clear, outside of those 2 projects that you just identified, the rest of these projects, to your knowledge, are reflected in Pepco's traditional test year compliance filing proposal.
Yes, to the best of my understanding.
And you know, as best as you understand it, these projects Pepco considers them reliability projects?
When you say reliability projects, can you elaborate what you mean?
Sure. So under the typical historical test year practice, and before the Maryland Commission, there's adjustments made to the historic test year to reflect certain post-test year reliability plant additions. So these would be projects that the company identifies as reliability focused, that close the plant after the test year period.
I'm not sure I'm in a position to respond to that because I was not part of that process. All I know is that Pepco provided me 15 investment plans to analyze. How they were treated in the rest of the case is unclear to me. That's beyond my scope.
Okay. But you would agree that these projects were proposed to be, or forecasted to be placed into service during 2026, correct?
Yes.
And not from September 30th, 2024 through, or September 1st, 2024 through March 2025, or 2026. Let me ask the question again. To your knowledge, the projects that were scheduled to close in 2026, were they scheduled to close between January 1 and March 30, 2026?
I don't know that level of details.
Okay. Well, thank you. No further questions.
Okay, so we'll proceed to staff.
Good morning, Mr. Sushita.
Put the microphone a little closer, please. Thank you.
Good morning, Mr. Sushita.
Good morning.
Staff has no questions for you. Thank you for attending.
Thank you.
Okay. Rejoinder?
None.
All right, then we'll proceed to questions from the bench. Did I skip Emmy? No, she said she didn't have any questions. Right. Okay, first question goes to Commissioner Hoover.
Actually, I'm fine. So.
Okay. McLean?
No questions, sir. Thank you.
Linton?
No questions, thank you.
No questions.
None from me either. You're free to go.
Thank you. Was I stopping you guys from having lunch?
No, not really. but I will ask, Mr. McKeel, who's your next witness?
Mr. Samuel Williams?
Do you expect this to be lengthy, or should I do lunch?
I don't control that, sir. I would hope it's going to be short.
Well, I'll roll the dice. Let's bring him up, and then we'll do lunch.
Thank you, sir.
Yeah, actually, I guess I should ask all of you, or do you have a lot of questions?
I have less than 60 questions, but I'll talk.
Did you say less than 60? 60?
And
Really?
more than 50?
Less than 60.
Oh, 6.
60.
60.
Okay, but is,
I'll talk then.
Okay, in that case, we're gonna break for lunch. We'll be back at 10 minutes after 1.
We've already got.
Your Honor, I just have one preliminary matter before Mr. Williams gets started.
Sure.
All the parties have waived on John Corsi, company witness John Corsi. So I was wondering, one, if the commission has any questions for him, we could make him available. If not, I could just go ahead and enter his testimony into evidence.
Anybody have any questions for Mr. Corsi? You have a lot of stuff there, so I'm looking at you. Linton, what about you? No. Nope. Yeah, we have no questions, so yes, go ahead.
All right,
Please
I'd
proceed.
like to mark for identification the direct testimony of John Corsi on behalf of the company as Pepco Exhibit number 20.
So marked.
And I'd also like to mark for identification the rebuttal testimony of John Corsi as Pepco Exhibit number 21,
So marked.
and move that they be admitted into evidence.
Without any objections, so admitted.
Thank you so much.
Floor is yours, Mr.
Yes,
Keel.
thank you, Mr. Chairman. Pepco would call Samuel Williams to the stand, sir.
Terrific. If you could swear him in, please.
I do.
Mr. Williams, will you state your name and spell it for the record, sir?
Samuel Williams, Samuel, last name Williams.
And how are you employed, sir?
I'm employed at Pepco Utilities as the Vice President of Electric Distribution.
And, sir, have you caused to be filed in this matter your direct testimony that I ask be marked as Pepco Exhibit 22 Public and 22 Confidential, or 22C?
Yes.
Okay, and so marked. I assume you want to mark.
And does that direct testimony consist of 45 pages and 3 schedules, sir?
Yes.
And is Schedule 3 to your direct testimony the confidential schedule, sir?
Yes.
Do you have any corrections or additions that you need to make to your direct testimony, sir?
I do not.
And if I asked you those questions in your direct testimony, would your answers be the same or similar?
Yes, they would be.
With that, Your Honor, I would move the admission of Pepco Exhibit 22P, or 22 and 22C.
Without objections, so admitted.
Mr. Williams, did you also cause to be filed your rebuttal testimony in this proceeding, which I asked to be marked as Pepco Exhibit 23?
Yes.
And does that consist of 11 pages?
Yes, it does.
Do you have any corrections or additions you need to make to that?
I do not.
If I asked you the same questions, would your answers be the same or similar?
Yes, they would.
With that, Your Honor, I would move the admission of Pepco Exhibit 23 and ask to do a little brief live rejoinder, sir.
Okay, without objections, so marked and admitted.
All right. May I just approach the witness to give him the testimony?
Sure.
Thank you.
This is good deal.
Mr. Williams, I've handed you a copy of OPC witness Mr. Fitzhenry's testimony, rebuttal testimony. Have you reviewed that rebuttal testimony, sir?
Yes, I have.
And could you turn, sir, to page 24 of that testimony? Let me know when you're there.
Okay, I'm there.
And on that page of the testimony is Mr. Fitzhenry talking about vegetation management.
Yes, he is.
And there, Mr. Fitzhenry discusses his claim that vegetation management and other alternative strategies can be deployed to improve system resiliency. Other than mentioning vegetation management, do you know if Mr. Fitzhenry has identified any other specific strategies, sir?
From what I can see, no, he has not. I would point out, according to staff in case 9353 in 2024, a 2024 filing, that Pepco was identified as having the best resiliency of any electric distribution company in the state of Maryland when it comes to the SAIDI MED metric.
And on page 24, Mr. Fitzhenry discusses the need that vegetation management, there at line 12, can improve, going over to line 13, can improve system resiliency. Do you have an opinion about whether or not Mr. Fitzhenry fails to address something regarding Sadie Med and vegetation management?
From what I can see, no, he does not. I think he fails to mention the impact that off right-of-way trees have on Pepco's resiliency. In 2025, off right-of-way trees accounted for 65% of Pepco's vegetation management outages, and that had a huge impact on our resiliency.
And what does it mean if a tree is off the right-of-way, sir?
If a tree is off right-of-way, that means that Pepco doesn't have the authority to trim or cut that tree. And given the stat that I just gave you all about the huge impact of those trees on our system resiliency, those outages will occur at some point, and oftentimes they occur during severe weather events where our resiliency is at its weakest.
Do you know, sir, whether or not Pepco asks customers who have off right-of-way trees whether or not the company can trim those trees or take those trees down?
When we identify trees that pose a more significant hazard other than just being in close proximity, we will approach customers to try to get permission or authority to cut those trees, but it's still up to them to grant that. If they do not grant that permission, then if that tree falls, we'll just have to deal with it in an emergent fashion, meaning putting the lines back up, et cetera, dealing with the outage.
With that, Your Honor, I've completed my live rejoinder, and he is available for cross-examination, sir.
Very well. We will begin with AOPA.
Your Honor, I passed out a few moments ago copies of the company's response to AOBA data request 4-1 through 4-29 in one packet.
The secret is revealed.
Thank you very much.
Your Honor, I would like to start by referencing the company's response to ALBA data request set 4, which includes questions number 1 through questions number 29. I think I would like to mark this packet with one exhibit, if that is one exhibit number, if that's okay.
Certainly.
Okay. That I would like to have these exhibits.
Well, hold on. That's okay under our customary practice, right? Yes. Then proceed.
Okay. I would like to have the company's response to ALBA data request number 4, questions 1 through 29 inclusive as ALBA Exhibit 5.
So marked.
Your Honor, can I just do a brief inquiry about that?
Sure.
Ms. Francis, on one of the data requests responses that are attached, I believe it is AOBA 4-22. Can you confirm for me that those highlights were put in by AOBA and that's not how Pepco provided that data request?
I would like to be able to answer that, but I don't know, and I will check. And if I find out that it is an AOBA highlights, then I will have them removed and substitute that one.
I didn't need them removed. I don't recall us highlighting them.
I don't know. I don't know if someone in my office did it. I will check on that and get back to you all tomorrow. Is that all right?
Yes,
Okay.
yes, ma'am.
Okay.
Okay. Please proceed.
Mr. Williams, want to take a moment and take a look through that packet? And tell me when you're ready,
Yeah,
okay?
I'm ready.
Okay. Are you familiar with the responses to data requests that the company has provided in answers to requests set forth by AOBA in data request set 4?
Yes, I am.
There are 29 separate requests, not counting subparts, that were made of the company in AOBA data request set 4. Would you accept that all of those requests references portions of either your direct testimony in this proceeding and or the schedules that accompany your direct testimony?
I would. Yes.
Okay. Each of the company's responses to the request set forth in AOBA data request set 4 lists you as the sponsor, except for the request to the last request, request number 29, which does not designate a sponsor. Are you the sponsor of Pepco's data request response to AOBA set 4, question 29, or can you confirm the accuracy of that response?
Yes, it's accurate from what I can see. Wait, I'm sorry. I was reading the second part. Yes, it's accurate. It's accurate.
Okay.
Yep. Okay.
Okay.
That better? Okay, thanks.
Are all of the responses to AOBA data request set 4 that are contained in AOBA Exhibit 5 true and correct to the best of your knowledge, information, and belief?
That's correct.
Now, please turn to page 5 of your direct testimony.
I'm there.
And I'm focusing on lines 7 through 9. Do you represent on those lines that the company's new business expenditures ensure, quote, timely and efficient, end quote, delivery of electric service?
I do.
Now, I would like you to reference Pepco's response to AOBA data request 4, question 4.
Okay, I'm there.
Okay. Am I correct that your response to Part A of AOBA data request 4, question 4, indicates the company does not have specific data regarding new commercial service connections that were completed in the month of April through December of 2024 and in 2025?
That's correct.
Now, Part B of AOBA data request number 4, question 4, asks the company to, quote, provide the data and analyses upon which the witness relies to demonstrate the efficiency of the new commercial service connections that were completed in the months of April through December and in calendar year 2025 to date.
I'm sorry, was that?
Can you confirm that's what it says?
Yes.
Am I correct that your response to Part B of AOBA data request 4, question 4, indicates that the company does not have data or analyses that demonstrate the efficiency of service provided for new commercial service connections?
Correct.
Now, I would like to focus on your Schedule SW-2, page 1 of 14. And this is a public schedule.
Okay, I'm there.
You're there, okay. I'm looking at page 1 of 14. Okay, thanks. Okay. At the end of the paragraph on the top of page 1 of 14 in Schedule SW-2, you state, quote, capital costs are 2024 actuals expenditures and budgeted expenditures in 2025 through 26, end quote. Am I correct that the dollar amounts you show for the projects presented within the schedule, that is Schedule SW-2, represent the dollars the company has spent or plans to spend on those projects within each calendar year?
2024 actuals, that's the test year. The others are forecasted, yes.
Okay. And that is what the company plans to spend on those projects within those calendar years, correct?
Per this testimony, yes.
Okay. Now, have actual or estimated contributions in aid of construction amounts been deducted from the dollar amount shown for capital spend in the first table on page 1 of 14 in SW-2?
Has kayak been
Yes.
deducted?
Have they been deducted?
I would ask for Connor Nelson to answer that question.
Okay.
Company witness Nelson. I meant-
Would you accept, subject to check, that new business projects represent roughly 94% of the capital spend in the table in the top half of the page in SW-2?
Could you, Ms. Francis, could you identify the the column that you're talking about?
Sure.
I'm sorry.
Sure. I'm looking at your first chart on page 1 of 14. Okay. And what my question is, would you accept, subject to check, that the new business projects represent, and that's the new business projects you have on that middle line, it says new business Pepco. You see that? In the chart, new business Pepco, year
Yeah,
2000.
I see it.
Okay, you see that?
Yep.
Represent approximately 94% of the total capital spend in the table, in that table.
Yeah, roughly. I could accept that.
Okay, thank you. Am I correct that the dollar amounts provided on the pages of Schedule SW-2 are not intended to reflect the cost of plant placed into service for an ITN within each calendar year for which the data is presented and do not include AFUDC?
Can you repeat the first part again?
Am I correct that the dollar amounts provided on the pages of SW-2, that's what's included in your exhibit, they are not intended to reflect cost of plant placed into service for an ITN within each calendar year for which the data is presented, and they do not include AFUDC?
I'm not clear on the first part of your sentence, so I will say I don't know. We could
Okay.
get that to you.
Okay. Well, let's just take a look for an example. Take a look at page 2, then you can take a look at page 3. Are the data presented on those pages, do they reflect cost of plant placed into service?
Oh, okay, I got you. Yes.
They do. Okay. Wait. Let me say the question again, because I think we got a little messed up. The dollar amounts provided in your exhibits, in the following pages, let's just say 2 through the end of the exhibit, they are not intended to reflect the cost of plant placed into service for each specific ITN within the calendar years which are set forth in this exhibit.
For the year 2024, where there are actuals in all of these charts, those are the plan additions for that calendar year, April 2024 through December 2024.
Okay. And for 2025 and 26?
Those are capital expenditures, not a part of the test case.
Okay. So are you telling me that for the 2024 actuals, the first number, let's just look at page 2 of 14.
Okay.
That 4,068,000, that is a capital expense, that is a number for plant placed in service.
Plan additions, yes.
Plant additions, okay. And the other two numbers are for capital expenditures.
Right.
Okay.
Yeah.
Now, please turn to page 14 of 14 of SW2.
All right, I'm there.
Okay. Now, the budgeted dollar amount for 2026 that you show in Schedule SW-2, page 14 of 14, for ITN 188565, Commercial New Business, Small and Medium Projects, and you show that number at $29,283,000, correct?
That's correct.
Okay. Would you accept that the 2026 budget amount is more than 3 times greater than the actual dollar amount of $9,604,000 that you show as an actual number for 2024?
I would-
Your Honor,
Okay.
I just want to object because those costs, now that we're doing the historic test year, are not at issue and not in the record, or should not, I mean, they're in the but shouldn't be. We're not seeking recovery of those costs in this proceeding. It's the test year costs that we're seeking recovery for, not for 2026. So I'm not certain why we're going down this line.
Your Honor, I think the record is confused in parts of what's in the company's request, what's out of the company's request. Some of the testimony that we didn't strike talks about the fully forecasted test year. Some of it talks about the traditional test year. I am just looking at the numbers on his page. They weren't stricken. And I should be allowed to ask, it's a very simple question. I'm asking him if the numbers, the actual numbers that they are asking for, and remember, the company is asking for post-test year adjustments in this case through July of 2027. So I should be allowed to be asking for this information.
I'm going to overrule your objection. I agree that there's a lot of data here. I'm confident that we'll be able to sort it all out in our deliberations. Please proceed.
Okay. Shall I ask the question again?
Sure.
Okay. The budgeted dollar amount for 2026 that you show on page 14 of SW-2 for ITN 188565, Commercial New Business, Small and Medium Projects, you show that number at $29,283,000, correct?
That's correct.
Okay. Would you accept that the 2026 budget amount is more than 3 times greater than the actual amount of $9,604,000 that you show as an actual number for 2024?
That's that place we went to. I would ask that we have witness Connor Nelson speak to the financials past the test year of 2024 actuals plan additions. He would be able to answer the questions related to future year spending.
Mr. Wilson, I'm only asking you.
I understand.
Is
but
29 million 3 times greater than 9.6 million?
that was my answer, though.
Your answer is that I need to ask that question to Mr. Nelson?
Correct.
Okay. Just for clarity, do the dollar amounts shown on SW-2, page 14 of 14, deduct dollar amounts for actual or projected CIAC receipts associated with the projects pursued under ITN 188565?
You're asking if kayak is subtracted from the 2024 test year?
I'm asking if the CIAC receipts associated with the projects pursued under your project name ITN 188565 5, is the CIAC deducted from the numbers you show on page 14 of 14 of your schedule SW-2?
As I stated, witness Connor will speak to the financials associated with the project, and I can speak to the operational aspect of the project.
Connor, by you mean witness Nelson?
Witness Nelson.
Okay,
I'm
okay.
sorry.
Given that the CIAC amounts are typically received in advance of construction, am I correct that CIAC amounts may at certain times be received from customers in a calendar year different from the year in which construction costs for the project are incurred?
That's correct.
In the development of the actual 2024 and budgeted amounts 2025, 2026 shown by ITN in Schedule SW-2, how do you account for CIAC amounts received or expected to be received in a prior calendar year?
In the prior calendar year. The way that we account for kayak and get the numbers you're asking, we utilize the terms of the tariff, for one, what we're able to charge in those aspects. We have a delegation of authority process with our engineers, designers, and engineer leaders that we go through, whereas though, a designer has one DOA level that has to be peer checked by an engineer has another level if the dollar amount keeps climbing, and then the manager has to peer check anything that an engineer is approving. We also have work management processes in place that are very restrictive to, before we start construction, we have to take a payment from the customer so that we aren't doing work that we aren't getting reimbursement for.
Let me ask the question this
Okay.
way, okay? When you were developing the actual, let's start with the actual amount shown, let's just say, let's look at page 14 of 14. When you were developing the actual cost of $9,604,000 for 2024 actual, how did you account for CIAC that you may have received in either 2022 or 2023? How do you account for that?
Each year is different. Your budget is a function of the net additions and subtractions. So there's no way to account for that in the previous year or future year. The customers have the ability to come forward, ask for service. It's non-discretionary. We have to provide it. So we can plan for one forecasted type of number, and it can come in totally different because of the uniqueness of each project. So that's how we account for it.
Wait, I guess maybe I haven't been clear. I'm not questioning how you get to the number right now, and I'm not questioning whether it's right or it's wrong or it's over or it's under budget. I'm saying in 2022 or 2023, you received a kayak contribution. Where does it show up? Does it show up in 2022? Does it show up in 2023? Or does it show up in 2024 when the plant is placed in service? Where does that CIAC, what year, when does it get deducted from the cost of the project?
I would ask that you refer to witness Nelson for that.
Okay.
Yeah.
Okay. That was the question I was trying to ask. Now, please turn to page 8 of your direct testimony.
I'm there.
And focus your attention on lines 14 through 18.
Yep.
And on those lines, I believe you indicate that the company's new business budget is developed based on historical data and any known future influences. Is that correct?
Correct.
Now, at page 8, line 17, through page 9, line 6, am I correct that you identify 6 factors that the company considers when developing its new business budget?
That's correct.
Now, is the first of the 6 factors you identify historical trends?
That's correct.
Now, please reference your response to AOBA Data Request 4-11. Tell me when you're there.
Got it right here. Sorry. Got you gave it to me. Okay, I'm there.
In AOBA Data Request 4-11, Part A, you were asked to provide the data upon which Pepco relied to develop the historical trends that you reference on page 8, lines 17 through 18 of your direct testimony. Do you see that?
You said 411, right?
411, Part A,
Part
top
A.
of the page.
Yep.
Do you need me to repeat that?
Yes, please.
Okay. In Data Request 411, Part A, you were asked to provide the data upon which Pepco relied to develop the historical trends that you reference on page 8, lines 17 through 18 of your direct testimony, correct?
That's not what it's reading on 411 for me. That's all. That's the only reason I'm asking.
Okay, let's look at the top
You
of the
said
page.
11?
411.
Oh, sorry.
411.
All right, I got you. Sorry. I was on page.
Page 5.
All right, yep, I see it. Historical trends.
Shall I do it one more time?
I got it.
Okay.
Yep.
Did you, I'm sorry, I didn't hear you. Did you?
Yeah, I said I have.
Okay.
Yep. And I got the question.
Okay.
Yep.
Am I correct that attachment 411? Okay. Am I correct that attachment 411A provides the data the company relied upon to assess historical trends for new business budget development?
Correct.
Now, in your response to Part B of Data Request 411, you identify the time period over which the data was examined to assess the historical trends to which you have referred, correct?
Correct.
Can I relate your response to Part B of AOBA Data Request 411 to the data provided in Attachment 411A to conclude that the dollar amount shown for 2023 represent partial year data and the dollar amount shown for 2024 represent budget projections?
I would ask that you reference company witness Nelson for that question.
What's concerning me, Mr. Williams, is your name is on the bottom of question 411. You submitted 411A. I'm asking you a fairly simple question. I'm asking you, if you take a look at the chart, does that show, in the words of your testimony, that the 2023 amounts represent partial year data and the dollar amount shown for 2024 represent budget projections?
Can you direct me to the 411A attachment? We're in your...
I think it's the next page in her document. If you flip it over,
That was on the page that she said. Okay. I'm sorry, ask me again. You can ask me again now. Thank you.
Just repeat the question.
Okay. Can I relate your response to Part B of AOBA Data Request 411 to the data provided in the attachment 411A to conclude that the dollar amounts shown for 2023 represent partial year data and the dollar amount shown for 2024 represent budget projections?
If we're talking about how we established that budget for 24, then yes.
Let's just take a look at page 14 of my data requests. This is question 411. On the bottom of the page is Pepco's response, and it says, the company has used a past 3-year spending history of 2021 to 2022 and partial 2023 due to timing for the trending analysis for the 2024 budget. Do you see that?
Yes.
So my question was just asking you to confirm that the data provided in 411 for 2023 was partial year.
Your Honor, I think he confirmed that in the answer to the
Yeah,
last.
that's what I just said. We used it.
Maybe I didn't hear him. I'm sorry.
We used that to get the budget for 2024. That was my answer.
Okay. So he did confirm it?
Yes, he just did.
Okay, thank you. In your response to Part B of Data Request 411, you indicated that partial data is provided for 2023 due to timing. Would you please explain for the record the causing of the timing constraint to which you refer?
As you are establishing a budget for a future year, all of your actuals may not have come in. There could be spend that's still coming in while you're putting your budget together for a subsequent year. And so that's what that partial means due to timing.
Okay.
You don't wait till the 31st to start working on the budget. You're already working on it ahead of time.
Now, your testimony for this proceeding was filed, the company's case and your testimony was filed October 14th, 2025, correct?
I'm not sure, honestly.
We will stipulate to that date.
Okay.
Are you able to tell me when were your projected budgets for new business projects developed for this proceeding?
I don't have an actual date for that. We could get you that information, but I don't have
Do you
it.
have a number you don't know?
Yeah, he said he'd.
He said he
You
could
get-
get that
you'll
data.
get
I'm
it.
just confirming you don't know the answer to that.
I don't know. I can get that. We can get that information for you.
Now, in parts C and D of AOBA Data Request 411, you were asked to provide the analysis the company relied upon to develop its claimed, quote, historical trends for new business ITNs. Do you see that?
I do.
Okay. Am I correct that your response to those parts of AOBA Data Request 411 indicate, quote, no specific analysis is available?
That's correct.
Is it your testimony that no quantitative analyses were performed to identify the trends that you claim to rely on for budgeting?
The analysis that we perform is based on the 6 inputs that are listed in my testimony on page 8 through 9. These are industry established practices that all mostly new business utilities will use to establish their budgets when it comes to new business work. New business work is, it's kind of dynamic. It's you're looking at the not only historical, but you're looking at the increase in cost. You're looking at the economy. Legislation may change, so you're using historical as your best case scenario in any known entities. We do have relationships with some developers who may say, hey, in 2025, we're going to do this body of work. Let's start to plan for it now. And so it's kind of that hodgepodge of historical and knowns to get to the budget.
I understand the 6 factors. I understand that you're submitting that that was industry practice, but my question is really going to, is there a quantitative analysis in your testimony where you used to identify the trends?
Your Honor, it's been asked and answered from the first question. No specific analysis is available.
You don't agree with that?
I will accept that, and I will accept that answer, but I was very specifically focused on quantitative dollars, quantitative numbers, and I think his answer was more general, so I was trying to pin that down.
Yeah, I was trying to answer with the fact that there's no way to give you quantitative numbers because it's an unknown of what the inputs will be, how many customers will ask for service that we have to provide. So there's no way to have a exact amount when you're establishing a budget.
Now, taking a look again at 411A, are you essentially saying that you intuitively determined how the historic cost data that you've presented in attachment 411A, I'm looking at 2020 through 2023, you intuitively determined how that historic cost data would let me just finish. Can you wait till I finish the question?
Yes, ma'am.
Just wait till I finish before you object. That you intuitively determined how the historic cost data presented in 411A would project into the future for 2025 and 2026.
I'm going to object to adding the word intuitively. The answer to DR Section C.
Your Honor, I object to Mr. McKeel testifying.
Hold on. He's explaining his objection.
What we did is explained in this DR response.
Your Honor, exactly what they did is not really explained in this data response. And
Are you pressing your objection?
They can move. I'll withdraw it at this point, Your Honor.
Okay.
are you essentially saying that you intuitively looked at the data from the historical periods 2020 through 2023 to determine and be able to project into the future how your projected budgets were set for 2025 and 2026?
Not intuitively. We use historical trend data, what we know about the industry, what we know about the economy. If it's projecting that we're going to have a great economic year, that projects to there will be more spending, there will be more building, there will be more economic development. Residential folks will have more discretionary income to do things with their properties that they may want to do that results in these requests for service. And if it's projected that we're going to have, just I'm just using it, the economic piece as an example, if it's projected that the year is going to be a down year, you wouldn't go into a year to say there's going to be a ton of spending, because historically the trends show when that happens, spend will dry up. So that's how we use that historical data to build out what we're looking at to budget the future.
Now, I just want to look at a specific ITN.
A little closer to the microphone, please.
Okay,
Thank you.
Okay. Now, I just want to look at some specific data for ITN 188565 listed in the left-hand corner of your response to 411A. You see that?
188565. 188,565, commercial, small, and
Correct.
medium projects. Okay.
Correct. Now, is the only data you have provided to support the company's assessment of the historical trend is budgeted data for 2024?
Correct.
Would your answer be the same for ITN 188654, commercial large projects, and ITN 188563, residential small and medium projects?
188,564, not 654, correct?
188654. And
564. No, you transpose the numbers. It's 188564. NB, commercial large projects. I do it all the time.
yes, and the second number is ITN 188563.
Correct. Yes, correct.
Okay.
By the way, little accounting trick here. If your numbers are off, if you're off and it's divisible by 9, it means you transpose something.
Okay.
Really?
Yep. Well. Well, sometimes maybe
Now-
it's usually a transpose.
Now, I'm going to ask you to reference your response to AOBA data request 4-12.
Right. If you're off by divisible by 9, difference. I can't find it.
Now, in AOBA data request 4-12, you were asked for data and analyses to support the company's assessment of expected customer demand for new business connections, correct?
Is that B? I just want to be clear, just B.
B. I'm looking at,
412B.
yes, yes.
Okay, yes, yes.
Would you agree that your responses to parts A, B, C, and D of AOBA DR 4-12 basically parallel your responses to the parts of AOBA data request 411?
Need to find 4-12B. I don't see 4-12B in the packet.
You don't
can
see
direct me to it. I know the other one was on the next page. This one isn't on the next.
I'm looking at 411 and 412, and I'm asking, is your responses to 4-12 except essentially very similar, if not parallel, to the same responses you gave to section 411? I mean, some of the words are exactly the same.
I don't see it in this packet.
It's the next page.
One is 4,
I have 412. I'm looking for.
She's looking at comparing it to 411.
Well, 412A isn't in there.
Yeah, it says 412A. That's what I'm saying. I don't see 412A.
Right.
Should I approach the witness?
Sure.
Okay.
Oh, I think you've.
Oh, it should be referred to 411A.
Yeah, can you repeat it? Sure. Just
Oh,
repeat it.
it's.
Do you want me to, do you need me to show you what I'm
No,
looking at?
just repeat it.
Okay.
Would you agree that in your responses to parts A, B, C, and D of AOBA data request 412, now I'm looking at page 15 of the document I handed you. Do you have that?
I got it. Yep.
Okay. Are they basically parallel or substantially similar to your responses to the parts of AOBA data request 411 that we were just discussing, which is on page 14?
I got it. Okay, yes.
Okay, thank you. Now, do you believe that the way the company is approaching the budgeting of your new business ITN represents a transparent process?
Yes, I do. The information that, if I could, to expound, the information that's used to build the budget is based off of information that was historical, and that's a known entity, the historical information, the trend information, as well as what's known in the industry in terms of what the drivers are, what the inputs are. So if the inputs are aligning with what we feel that we said they are, increase contractor costs, customer demand or lack of demand, legislation or regulations that are known, plan developments, which we can, point to at some point after fact. I mean, these are inputs that aren't known at the time when you establish the budget, but at the end of the day, these are things that you should be able to look to and say, that's industry standard, these are reliable inputs to establish a budget.
But for your historical trend analysis, the only information we have, the quantitative information we have, is that what was requested in AOBA 4-11, attachment A. So I'm just taking a look. We have some numbers. We have new business commercial, approximately 19 million. We have 2021, 18 million, approximately 2022, 23 million. We don't know what those numbers are comprised of, correct? All we know are those. This is what we know in terms of your historical trend that you based your budget on that was filed with your as a
It's
data.
not project by project.
I'm sorry?
It's not project by
Correct.
project.
Do you agree?
Yeah, it's not project
Okay.
by project.
Now, let's move on to your response to AOBA data request set for question 13. And that's on page 16
Yep.
of AOBA Exhibit 5. Tell me when you're ready.
Yes, I'm there.
Okay. Does your response to Part B of AOBA data request set for question 13 indicate that, quote, in most cases, the company has blanket contracts with contractors under which, quote, rates are negotiated and the typical length of such blanket contract is, quote, typically 3 to 5 years?
Where in my testimony does it say 3 to 5 years?
I'm looking at your response to data request set for question 13.
Got it. Question B.
Yes.
And my answer is contractor rates are negotiated and the teams involved, supply project management, are constantly monitoring market conditions. Okay. Got you. Yes.
Okay.
Yep.
Now, let's focus now on Part D of your response to 4-13.
Okay.
And that provides a table that detailed budgeted costs for contractors and for Pepco's labor by ITN for the years 2025 and 26. Do you
Correct.
see that?
I do.
Would you accept, subject to check, that the data in the table provided as part of your response to Part D indicates that for the years 2025 and 2026, over 73% of the company's labor cost in each year are spent on contract labor?
%73% of the contractor labor costs of the total Pepco labor costs?
Correct. Just to help you,
No,
Mr. Williams,
I see it. I see it.
I'm
I'll
looking
take
at
your
the
word. I'll-
100 million, I'm looking at the
I'll
100.
take your word for it. I'm just trying to do the calculations across both, but.
So
I was looking at the 100,957,000, and I divided that by the $136,860,000. Usually accept that's the 73%.
Yeah, I'm not going to say I accepted the 73%. I'll say, witness Nelson can speak to future years of, I know it's in my testimony, but this is outside of the test year. So I would go to witness Nelson for that.
For Pepco's overall new business activities in 2025 and 2026, can you tell the Commission Pepco's average hourly fully loaded cost for Pepco labor and the company's average hourly cost for contract labor?
Your Honor, I'm going to object based on your rule number 4 that cross-examination should not be a substitute for discovery.
Your Honor,
And if she's asked this question in discovery, she can show it to him.
Your Honor, yeah,
No, I was just saying I was reading through here. I couldn't find it.
so you don't know the answer to that.
I'll let them rule.
Your Honor, we thought we did ask this question in discovery, and this is what we got, was all of these responses to Section 4. We
Well-
did ask those questions in these data requests. We asked it when we got to,
Look, I'm going to overrule the objection, but it appears he doesn't know the answer, so I think you should move on.
okay. Can you tell me, Mr. Williams, are contract labor costs per hour for the performance of comparable tasks generally greater than or less than the cost Pepco would have to incur if comparable labor services were provided by Pepco employees?
Not at all times. It depends on the function of work being performed. There's a lot of new business functions that take place. You have design work, engineering work. You have the actual execution of the work. So some could be, higher on maybe average, but some could be less. It's just a.
Let's assume for the purposes of my I didn't mean not to let you finish. Did I
Okay.
cut you off?
Go ahead.
Let's assume for the purposes of my question that the work that we're asking to be performed is the same. So are the contract labor costs for performance generally greater or less than the cost Pepco would have to incur if it was done by internal Pepco employees for the same work?
And I'm saying it depends on the function of work.
Okay. Now, let's turn to the executive summary of your rebuttal testimony.
Okay, I'm there.
1 minute. And the last sentence of the executive summary asserts And the last sentence of the executive summary asserts that the accuracy and appropriateness of the company's treatments scratch that. Does the last sentence in your executive summary assert that accuracy and appropriateness of the company's treatment of contributions in aid of construction?
Not those exact words, but yes.
Have you presented evidence in your testimony and schedules in this proceeding regarding the accuracy of the estimates upon which Pepco's billing of CIAC are based?
No, we haven't.
Now, please turn to your direct testimony at page 13. And I'm going to look at lines 13 through 14. And on those lines, you state, quote, CIAC is based on the estimated cost to perform the work. Do you see that?
I do.
That's correct?
That's correct.
Has the company ever overestimated or underestimated the cost of the work to be performed?
Over or under?
Correct.
And from a budgeting perspective, I would say yes.
Would you agree that estimation of inaccuracies Would you agree that estimation inaccuracies are fairly common?
No, because we will state in the beginning and inception when we're putting the budget forward that it's not going to be a budget that lines right up with the actual because of the unknowns that go with establishing a new business budget. The inputs change as the year goes on. The amount of services that are requested from customers change. You have no way of knowing that when you're establishing a budget. I'll give you a prime example of just say this year. This year, as you're establishing a budget for just say 2026, you're factoring in all costs of what you've known from a historical perspective. At some point, the economy switches because of what's going on from an oil perspective. Now diesel is $6 a gallon. When we put our budget together, diesel was like $4 a gallon. All of those inputs change, so now all of those new business jobs will incur the throughput of these higher costs that contractors will charge you for higher costs that way. Our internal crews that are driving vehicles to these jobs, the diesel goes up. So these are things that you cannot know when you're establishing a budget. So it's not from a lack of good financial discipline. It's a function of you have inputs that are dynamic in the new business space, and they can change. And so that's how you get to that point. So the budget is as accurate as we can get it, but at the end of the day, where your actuals hit from what you budgeted, there's a likelihood that there's going to be some differentiation. Sometimes it's higher, sometimes it's lower.
Okay, I understand that.
Okay.
And I'm not challenging that answer.
Okay.
But my question, I'm really focused on something different. So if you have CIAC that was assessed in 2023 at one number, because you've estimated it based on your historical trends before that, and now all of a sudden, the work is being done in 2024, 2025, you may have underpriced the cost of that CIAC, and that initial CIA charge would be essentially inaccurate. Is that correct?
It would be different.
It would be different. Okay, and the same thing could happen. Prices, let's just say we're factoring in the price of cost of gas. We all hear about that. And now in a year from now or 2 years, it's substantially lower. You may have overpriced what you budgeted for CIAC for 1 year. That would be lower by the time that it comes into the project.
I think the way you're categorizing it, though, it isn't inaccurate. There's a job that you could have performed in 2024.
It's
the
different.
job
Let's just say it's
Okay.
different, correct?
It's
different.
Okay.
Okay. Now, would you accept that Section 10E of page 44 in Pepco's Maryland General Terms and Conditions specifies that contributions in aid of construction for service connections are non-refundable? And I have a copy of that
Yeah.
for you to see.
What is this document? Is this the standard?
Maryland Terms and Conditions.
Oh, it's this. Okay.
That's what and I have several copies.
No. That's that. Unless the commissioner wants it, I don't.
I don't have them committed to memory. I'd like to see a copy, but if it's the terms and conditions on file with the commission, that's what we follow.
Another piece of paper. It doesn't seem like it's gotten any warmer.
I do good this. I'm gonna give one to the witness.
I'm not complaining.
That's the one, he's the one who needs it.
Yeah,
What page are you on, Fran?
Okay, thank you.
In the building, ignore
Much
it.
appreciated.
As usual.
Just right.
We ought to get one of those fire pit things. You know? Or maybe, yeah, or maybe a 55-gallon drum with, like in the strikes in the old days. Sure.
Opie's gonna go
What
get
the-
his heater.
What the hell? Okay. Here you go.
What is this?
This is the, whoops, yikes.
Okay.
We're good.
Yeah. Oh,
You good? Okay, Mr. Williams, you have a copy of
there's
I
a
did.
bunch here.
second page of the exhibit that I handed out. And if you take a look for where it says Part E, charges for service connections, the last section, you would agree says such fees or contributions are non-refundable?
Just looking for it in paragraph.
It's the last sentence.
Last sentence.
Under E, the last
Yep,
sentence.
I see it. I see it.
Do you agree?
Yes.
Okay. Now, am I correct that customers are required to make CIAC payments for new service connections prior to the start of construction?
Most customers, that's the agreement. Some entities like WMATA, federal customers, state customers for facility relocation jobs and such, most often they'll pay near the end.
Okay. But you would agree that most commercial customers are required to make kayak payments before, correct?
Correct.
Okay. Now, if these are non-refundable,
Correct.
isn't there an incentive for the company to overestimate what those costs might be?
No, because the practices that we use are under the terms and conditions of the tariff, and they're shared. There's no reason to inflate the costs. We're showing what the contractor inputs are at some point within the job breakdown. No, they aren't inflated, and they're spelled out in the cost letters.
They're spelled out in the agreement with the customer, correct?
Correct.
Okay, and each customer is different, correct?
That's correct.
Okay.
Each job is unique. So you could live in a townhome, Ms. Carey could live in a townhome. It could look like this is the same type of job that's going to be run. The capacity available from the feeder at which you're located near could have capacity that's available, so we could probably easily hook your service up. Ms. Carey, she could be on an underground feed and capacity isn't available, so they may need to be feeders ran, they may need to be a transformer installed, and that kayak will be more.
If after the start of construction for a new service connection, Pepco finds that it has underestimated its cost for the customer's requested service connection, does Pepco ever bill a customer for additional CIAC?
So it should have been redlined out.
I would say that I can't say that we haven't rebuilt. There could be
Could you
situations.
say that a little louder?
No, I'm saying that there aren't situations. I can't say there aren't situations where we haven't rebuilt customers based off what we found.
So the answer is sometimes.
Sometimes.
Okay. If Pepco overestimates the service connection costs for which a customer is asked to make a kayak contribution, does the company have an obligation to compensate the customer for any overestimated portions of kayak?
I can't say an obligation. No.
Am I correct that your testimony and schedules in this proceeding provide no information that a third party could use to independently verify the accuracy and appropriateness of the company's kayak determinations?
I'm sorry, repeat it one more time, please.
Okay. Am I correct that in your filed testimony and schedules in this case, you provide no information that a third party could use to independently verify the accuracy and appropriateness of the company's kayak determinations.
That's correct.
Would you agree that verification of the proper treatment of kayak receipts necessarily involves assessments of the appropriate application of kayak receipts to project costs, such that the dollar amounts proposed for inclusion in plant and service properly deduct CIAC receipts from the cost for which inclusion in plant and service for rate-making purposes is requested?
I would refer you to Mr. Nelson for that answer.
Can you identify where in the company's filed testimony and schedules in this case the information necessary for a third party to verify the company's removal of kayak from the cost of new business projects is presented?
Are you able to point me to that in my testimony?
No, I'm asking, is it in your testimony?
Oh, so I think I answered it right. You asked, could we verify if a third party could find it in my testimony, and I said no. So is it the same question?
Okay.
It sounds like the same question. That's why I asked.
Asked a different way?
Yeah, that's what I'm saying. The same question.
Okay.
I'm on the three-strike rule.
At page 14, lines 10 through 11 of your direct.
Direct, okay. I'm there.
Okay. You state that the approach the company employs, planning and cost estimation for new business projects, ensures that those projects, quote, deliver value to both new customers and existing customers, correct?
Correct.
Am I correct that nothing in your filed testimony and schedules attempts to quantify the value the company's approach to project planning and cost estimation has provided to existing customers in any past or projected period?
When you say quantify, you could be thinking about it from a dollar value perspective.
Correct.
But if a customer needs service and we provide that service, which is not discretionary, and in order to do so, we need to upgrade the, just say, backbone, the feeders, the underground distribution system in that area. Now that upgraded system provides a benefit to incoming customers. So you put more load on the system, you're able to pull from that and provide more service. So that's a quantifiable thing in my perspective, from my perspective.
Even though there's not a dollar amount attached to it.
Yeah, it's...
Okay, now, taking a look again at your executive summary for your rebuttal testimony.
I'm there.
Okay. In the last sentence of the fifth bullet, that's the bullet which says new business commercial investments at the bottom of the page. You see that?
Yep.
Does that state contributions in aid of construction accounting is accurate and consistent with Maryland tariffs, regulatory accounting requirements, and sound rate-making principles? Agreed? Agreed?
Yeah.
Okay. Am I correct that you provide no quantitative information or analyses to support your claim regarding the accuracy and appropriateness of the company's determination of kayak amounts?
I'm going to object. That's been asked and answered now 3 times.
Well, he answers it not in a quantification way. He answers it in a very general way. And I'm trying to get an answer, a clear yes or no, that there is no quantification in his testimony. And I'm having trouble getting the witness to answer the very specific question.
Well, I think I'm going to sustain this objection.
Okay. Now, taking a look at your response to question 4-29, that's the last page
Page, yes,
of AOBA 5.
yes.
Now, that response in regard to your qualifications, it states that there's no references made to any experience in the area of regulatory accounting, correct?
That's correct.
Okay. Now, a large portion of the project costs for which you are responsible in this proceeding are associated with new business, correct?
That's correct.
Okay. Can you identify the primary FERC accounts in which costs for new business are recorded when plant is placed into service?
The
I'm going to object. This is not a quiz. They could have asked this in a data request consistent with rule number 4.
Your Honor, I know what the FERC accounts are. I'm asking him, does he know what the FERC accounts are?
I'll overrule the objection. Answer it if you can.
That answer can be answered by witness Nelson.
My question
I
is
understand.
not whether somebody else can answer it. I'm asking, can you answer it?
And I said that the witness Nelson can answer the question.
So your answer
That's
is
my answer.
So your answer is no. I defer to Mr. Wilson.
My answer is witness Nelson will answer questions about those FERC accounts.
Are you presenting yourself in this case as an expert on sound rate-making principles?
Not an expert, no.
Now, just briefly, looking back at your introduction in your testimony, or in the response to AOBA Data Request 429. Now, there is nothing in the response to 429 or in the introduction to your testimony which reflects your presentation of testimony on any subject in a previous regulatory proceeding. Is that correct?
Correct.
Okay. Now, just want to reference your response to AOBA Set 4, Question 15.
Just make sure I'm in the right place.
Set 4, Question 15. I have it on page 20.
That's correct.
Are you ready, Mr.
Yeah,
Mr.
I'm there, sorry.
Now, in parts B, C, and D of AOBA Data Request Set 4, Question 15, Pepco is asked to provide information regarding identified large-scale projects and their expected timing, correct?
Correct.
Okay. Am I correct that your response to parts B, C, and D provide no identification of any specific large-scale projects and asserts that such projects are not generally known in advance?
That's correct.
Okay. In response to Part A of your response to AOBA Data Request Set 4, Question 15, that indicates that large-scale projects are projects that can include multi-year or multi-phase requiring major infrastructure buildup or upgrades. Is that correct?
That's correct.
Doesn't the company need considerable advance notice before starting construction on facilities to support multi-year large-scale projects?
Can you repeat the first part of the question?
Doesn't the company need considerable advance notice before starting construction on facilities to support multi-year large-scale projects?
Correct.
Your response to parts B through D of AOBA Data Request Set 4, Question 15 starts with the reference to the full list of new business projects. Am I correct that your response does not provide even a partial list of identified large-scale projects?
What it's saying is that those projects are generally not known in advance. So you wouldn't, excuse me, did you say something? Oh, I heard somebody say something. Are not known in advance.
Did you just, I didn't hear your full answer. I don't know if you
No,
were.
I was answering, and somebody said something, so that I thought you had said something.
No.
Okay. All
Could you repeat your answer so I
What
hear
I was
it?
saying is that full list is not generally known in advance. You have customers that may come forward tomorrow. Like I said, folks are generating projects and they're not including us. After they get to the point where they're ready to go, they may come to us and say, okay, we want to execute this work in this part of the service territory, when they could have come to us in advance. And it's one of my bullet points earlier when we talked about the 6 bullet points of how a kayak budget is created with known developments. If you don't know about the development, you can't always have that included, which is, so that's how sometimes that you don't have that full list.
Okay, my question was more focused on, your words are the full list of specific new business projects are not known in advance. I was asking, was there any list of projects that the company knows about in advance? You said the full list.
Sometimes, but not the full list. So I'm saying partially you have no, that's one of the 6 inputs, known developments. But unknown developments are also part of the inputs, so we wouldn't have the full list, is what I'm saying.
Okay. Now let's just look at your testimony at page 20, your direct, at lines 11 through 13.
All righty. Page 20. I'm there.
Okay, now, your direct testimony at page 20, lines 11 through 13 indicates that Pepco is currently designing to support service extension to a planned 18-megawatt data center in Montgomery County. Why was that activity not referenced in your response to AOBA data request set for question 15?
Any part of the 4-15 you're referring to?
Yeah, why didn't you, on page 20, lines 11 through 13, you said Pepco is currently designing to support service extension to an 18-megawatt data center in Montgomery County.
Okay.
Why wasn't that on your list of projects in response to 4-15?
We didn't list every large project in the response. So why we didn't list that one is just a function of we gave you a snippet of some, but this one wasn't listed in that list.
Can you tell the commission where specifically in Montgomery County the referenced 18-megawatt data center will be located?
I don't know the exact location.
You don't know?
I do not know the exact location.
Okay. Now, please reference AOBA data request set for question 27. And that's on page 34 of
Got it.
Exhibit 5.
I'm there.
Am I correct that the last sentence of your response to AOBA data request set for question 27, Part B states, quote, "The company does expect increased commercial spending in 2026 based on prospective data centers and EV charging station customers in Maryland are discussing various locations with the engineering team." Is that correct?
That's correct.
Okay. Is it the company's position that discussions relating to various possible locations for prospective data centers and EV charging stations justify Pepco's incurrence of cost for such potential customers, even if customers have made no financial commitment to Pepco for the service connections that would be needed?
I would say large developers that we have history with that are known to execute on projects, you're prepping and getting prepared for those economic development opportunities such as EV charging. So it would be incumbent on us to plan for that and put that in our budgets. It's not as if some residential customers are coming to me and saying, hey, I think I'm going to run a service next year. And then I say, okay, let's put that in the budget. These are large developers. These are state entities. The state is pushing for EV, electrification, etc. So we plan for it. That's the answer.
Would you be planning for this 18 megawatt data center that you don't exactly know where it's going to be located?
The company knows where it will be located. It's not, I don't know where it's going to be located.
By the company, you're not referring to Pepco. You're saying the company that wants to build the 18 megawatt.
What I mean is I specifically don't know where it's located, but I have a team of 1,000 people. I have engineers, I have directors, I have principal business analysts. It's their job. It's their job to know who owns that project, where it's located, dealing with the developer, etc. So planning for that is part of the project. Having discussions with those data center representatives is part of the project. And once they're ready to execute and say, okay, let's get a cost letter together to say, let's go and start the process of engineering, design, and at some point constructing, you have to be prepared for that.
So, based on discussions with data centers, whether it's this 18 megawatt or some other data center, someone under your direction would have discussions, and after those discussions, the customer would not have executed anything, but you would go ahead and start planning for those data centers, even if there was no financial commitment on the part of that data center.
Well, if I'm reading my testimony, it says Pepco is currently designing to support service extension. So if we're designing, that means we're performing work. Designing and engineering is part of designing it. This is how it's going to look, etc. There's a cost to that.
Yes,
Design
and you would go ahead with that, even though there was no financial commitment on behalf of, we're talking about that 18 megawatt data center or some other data center, correct?
It's in the tariff. You have to do the design in order for the customer to say, okay, yeah, that's feasible. Let's go.
Okay. Your Honor.
Brought up on a napkin, for something this big. This is a huge load, so we will have to go through that process.
Your Honor, I'm done with my questions. However, I'm going to move AOPA data request set 4 in its entirety, questions 1 through 29, into the record. I did not specifically ask a question about every data request in this packet. I am anticipating a potential objection from Mr. McKeel. I am perfectly capable of going through all of them and asking a specific question, but I'm trying not to do that unless I feel that it's necessary. So if there's no objection, just anticipating, I've known Mr. McKeel a long time, I'm just anticipating, if there's no objection, I will stop now. If there's going to be an objection, I'll keep going.
I have looked at all of these data requests, and they're sponsored indeed by this witness, so I will not be objecting.
Then I will conclude my cross and move the admission of AOBA Exhibit 5. I did not mark this one page from Maryland General Terms and Conditions. It's my understanding I can cite from this document. Otherwise, I could mark it and move that
It's
to...
a thing of beauty. Okay, yes, admitted into evidence.
Should I admit
No,
this?
not that.
Okay.
Your
Okay.
AOPA 5.
Okay.
All righty then.
I'm done.
Yes.
Okay.
I forgot there are other people to call.
Yeah.
I'm so sorry.
That's okay. MEA?
No questions for this witness.
Okay. People's Council.
No questions, Your Honor.
Okay. Montgomery County is still not here, so we'll go to staff.
Staff has no questions for this witness. Thank you.
Thank you. Redirect?
All right, now it's me. Mr. Williams, do you recall Ms. Francis asking you questions on your schedule SW2 in your direct testimony?
Correct.
Do you recall those questions?
I do, yes.
And those are the problem, solution, and justification statements that Pepco put forth in this matter. Is that your understanding?
Correct.
And do you know those are capital expense numbers included in Schedule SW2? Is that your understanding, sir?
Capital expenditures, yes.
And for the plant in service that you know about in this matter, that would be in table 1 on page 4, going over to page 5 of your direct testimony. Is that your understanding, sir?
That's correct.
All right. Do you have AOBA Exhibit 5 handy, sir? Those were the DR responses. And I'm looking at, do you recall the questions that Ms. Francis asked you on Pepco's response to DR 4-11, sir?
Get there.
It's on page.
Yep, I'm there.
And if you could, Ms. Francis asked you a couple questions on the attachment there.
Yes.
And she specifically asked you a question on, man, these numbers are small, ITN 188565 and 188564.
Correct.
And there's blank spots there for 2020 through 2023, right?
Correct.
Can you look at the additional comments page section there?
Correct.
Does that indicate the reason for those blanks is the fact that those ITNs were split into 2 different groups, and that's why there's no information from 2020 to 2023?
That's correct. During those years, you had commercial projects that were over 1.5 million and ones that were under 1.5 million that were commingled, and we wanted to bifurcate those to show the ones that were over 1.5 million, and so that you could, be able to look at that spend in a more specific manner.
And so that's why the information's
That's why
not
the
reported.
information isn't there.
Can you turn, sir, on, I'm again still in AOBA exhibit number 5, and Ms. Francis asked you some questions on page 17 there of 413 on the table that's at the bottom there on D for 2025B and 2026B. Do you recall those questions?
Correct.
Is it your understanding, sir, that those are future costs not being sought for recovery in this case?
Correct. Capital expenditures with future costs, not in the test year.
And so they're not being sought for recovery in
Not
this
being sought for
proceeding?
recovery.
And is it your understanding that Mr. Nelson, in his testimony, is providing the test year historic costs?
That's correct.
That's all I have, Your Honor. Thank you very much.
Okay, so we will commence with commissioner questions in the order of McLean, Linton, Suchman, Hoover, and the chair. So, Commissioner McLean.
Thank you, sir. Good afternoon. I just had one thing I wanted to hit. It's more of a curiosity thing than anything. In Mr. Oliver's SIR rebuttal, do you have that in front of you, sir?
You have a copy of that? Yeah.
If you just bear with me.
Sure, take your time, sir.
Did you say Mr. Oliver's SIR rebuttal or the supplemental SIR rebuttal?
I think just the SIR rebuttal. Yeah, it's the SIR rebuttal, ma'am.
Okay.
You're,
Not my book, so.
you're fine.
And I ripped the page, and I apologize, Mr. Curry.
Well, it's not yours, so don't worry about it. Page 28, sir,
Okay.
and 29.
Okay, I'm there.
Mr. Oliver's referencing that there was a data response. It was actually AOBA data request 4-1A that referenced 418 new service connections for commercial large new business projects between April 2024 and December 2024.
Correct.
Okay. And on the next page, sir, he notes at line 7 that the data response was updated and that 418 dropped to 4. And if you look at AOBA Exhibit 5, the first, very first data response is it has a chart. It's the very first page, sir,
Okay.
of the data response.
You talking here?
Yes, sir. Yes, sir. In that first column, it's got 4 under the commercial large projects.
Okay. I see.
Okay.
Yeah.
Yeah, so it sounds like Mr. Oliver is saying that number went from 418 to 4.
Yeah, I'm not aware of why it dropped from 418 to 4, to be honest.
Okay. Thank you, sir.
Commissioner Linton,
We can get.
Thank you, Mr. Chairman. No questions.
Commissioner Suchman.
Good afternoon, Mr. Williams. I want you to turn to your direct testimony, page 2. And I wonder if you could just read the first sentence. So it starts on line 10.
Okay, the purpose of my direct testimony is to support the capital investments being made in this fully forecast test year, specifically relating to new business and facility relocations, which deliver benefits to customers.
Okay. So the purpose of your testimony was to support the fully forecasted test year.
That's correct.
Okay. Is there any reference in your testimony, whether it's the direct or rebuttal, to the traditional test year compliance filing?
Not that I can point to.
Yeah, I can tell you it's not. So
Yeah.
actually, I sort of did a scan to see.
Yeah.
And so I guess I'm trying to understand how your testimony, maybe you could explain to me how your testimony supports the company's traditional test year compliance filing.
I would say because there are components, if you look to, shouldn't be too far. If you look at my testimony, page 4 and 5 at table 1, and it talks about the planned additions exceeding $1 million. The third column in, it talks about a bracket of time between April 2024 and December 2024, and those would be included within that test year period. And so, because I was able to testify to that portion, I believe that's a rationale.
Well, I mean, the problem is, listening to the cross with Ms. Francis, and there was a lot of testimony about 2023 and 2024 where it was budgeted but not actual. And I guess that would work if we were looking at a fully forecasted test year, but now that we're doing a traditional test year compliance filing, I'm concerned that there's not the clarity that we need, and that's one of the reasons why we asked Pepco to do redlining is so that we could know what's in and what's out. And I have to say that I don't have a clear sense from your testimony of what's in or out, and that's important because we have to decide if you've made the case, and I guess I'm not really clear on how to move forward on this because this testimony really is about supporting a fully forecasted test year. So I don't know in these numbers, unless you can be really clear about the breadcrumbs, I'm not clear about what we're supposed to be looking to and what we're not supposed to be looking to. And so I'm just saying that this is,
The reason I forwarded some of those questions related to spend outside of what was in my testimony was because witness Nelson can connect those dots for you in regards to questions that were asked about budgeted years that weren't in my testimony.
Okay.
So what
And I'm not. You prepared your testimony assuming one case, and then things changed.
Right.
And I'm hoping that Mr. Nelson can take your testimony and show us what's in and what's out, because at this point, and it's no reflection on you, it's the situation we're in right now, but I don't know what's in and what's out.
No, understood.
Okay, thank you.
Hoover?
So during your rejoinder, I thought I heard you say that when it came to vegetation management, that I think it was 60% of the tree issues are related to trees not in your right-of-way.
Correct.
Is that true for your entire service territory, or is that just a piece of it?
It's true for the Pepco service territory.
Okay, so Prince George's and Montgomery County.
That's correct.
Okay. So, and I think your next statement was, so for the trees that are not in your right-of-way, you ask the property owner whether or not you can do something to the tree, and if the property owner says, take a hike, you just go away, and if it falls down, you then deal with it.
That's correct.
All right. Has the company, is this true even if the situation is that the tree is obviously dead?
I would say, we have professionals in the veg management space, company employees and contractors that we would send to look at those issues. And when we find a dead tree, that becomes what could be deemed a hazard tree in our, and then we would try to make contact with that customer to say, hey, please let us remove this. But you cannot just go on someone's.
No, I understand you can't, but I guess what I'm looking for is there anyone else, like the county government, municipal government, state government, that you could talk to about what is obviously a hazard tree to get some relief?
We work closely with our GRA teams when we're dealing with customers that we can't get resolution with within the operation space, and allow them to intercede on our behalf. It doesn't always end in them being able to be successful, but we do utilize those levers.
Okay, so you're not just
throwing our hands up.
Okay, I understand. Okay, all right, that's it. Thanks.
Okay, I have no questions. It's a good time, I think, for a 10-minute break, so we'll come back a teeny bit after 3. I have 3:01.
Thank you.
3:01, 3:02. Before we get started here, let me just say that I mean, it had been my ambition to complete Pepco today, but that's clearly not going to happen. So I'm going to have us go no later than 6, but tomorrow is going to be the day where you have to bring lunch and dinner. We're going to power through tomorrow and get as much work done. I just do not want this to... Oh, somebody did bring a heater in here.
Put your pizza orders in.
I don't want to have this flow into Monday of next week, so tomorrow's going to be the day where bring extra goodies.
So are you saying there won't be a lunch break, or?
Oh, there'll be a lunch break, but they'll definitely.
It'll be a 15-minute.
So
Yes,
we're
Mr.
going
Keel.
to try and finish, I just want to get clarification, I'm sorry. We're going to try and finish all Pepco witnesses tomorrow or all witnesses?
Oh no! I mean, we're stuck here until Friday. So, but I definitely want to complete Pepco by tomorrow.
Okay.
Yeah. So again, as always, we'll play it by ear. But please.
One other preliminary matter before I turn it over to Ms. Curry. The data request that had the highlights in it, we're responsible for those highlights, and that's the way we served it. So it can go in, and there's no question about that. My apologies to Ms. Francis. I talked to her off the record. We're friends. Long time.
There's an I'm sorry. What
I was
did
going
you
to say, is that the heater? Because that kind of smells.
I smell something burning. Please present your witness.
The company calls...
Settle down, people. Come on, settle down. All right, go ahead.
The company calls Mr. Adrian McKenzie to the stand.
Yes, I do.
Mr. McKenzie, please state your name, title, and employer for the record.
My name is Adrian McKenzie. My title is President, and the company is Financial Concepts and Applications, Inc.
And could you spell your name for the court reporter, please?
It's Adrian, A-D-R-I-E-N, last name McKenzie, M-C-K-E-N-Z-I-E.
Mr. McKenzie, do you have before you a document entitled Direct Testimony of Adrian McKenzie?
Yes, I do.
Does that document consist of 60 pages and 11 schedules?
Yes, it does.
Was that testimony prepared by you or under your supervision and direction?
Yes,
Do you have any corrections or deletions to make to your testimony at this time?
I do not.
If I asked you the same question today under oath, would your answers be the same?
Yes, they would.
Your Honors, I would like to mark the direct testimony of Adrian and McKenzie on behalf of the company as Pepco exhibit number 24.
So marked.
Mr. McKenzie, do you have before you a document entitled Rebuttal Testimony of Adrian McKenzie?
Yes, I do.
Does that document consist of 123 pages and 16 schedules?
Yes,
Was that testimony prepared by you or under your supervision and direction?
it was.
Do you have any corrections or deletions to make to your testimony at this time?
Yes, I have 2 typographical errors to correct.
Thank you. Can you read those into the record, please?
The first one is on page 57, line 23.
And what does that change?
Mr. Walters should read Mr. McAuliffe.
Thank you, Mr. McKenzie. And what is the other error?
On page 123, line 1.
And what does that change?
OPC witness Garrett should read staff witness McAuliffe.
With those changes, would your, if I asked you the same questions today under oath, would your answers be the same?
Yes, they would.
Your Honors, I would like to have the rebuttal testimony of Adrian McKenzie on behalf of the company marked as Pepco Exhibit number 25.
So marked.
And I'd like to move both of those into evidence.
Without objection, So admitted.
I have some brief rejoinder for Mr. McKenzie. Right, Mr. McKenzie, referring to staff witness McCullough's testimony, rebuttal testimony, on page 7, lines 8, and at page 11, line 14 of his rebuttal testimony, Mr. McCullough says that your position that higher interest rates imply a higher cost of equity is a, quote, overly simplistic argument to explain a complex subject. Do you agree with that view?
Yeah, I disagree with that view. I think, in fact, Mr. McAuliffe is overcomplicating a simple relationship. Bond yields are an observable benchmark for changes in capital costs, both magnitude and direction. They're widely reported in the investment press. They're observable. We don't need to debate about how to apply models like the DCF and the CAPM. And so they're also very easily understood by investors and accepted. So, for example, just like when the 10-year Treasury bond yield goes up, the yields on new mortgages generally follow. When the yields on utility bonds go up, it makes sense that the cost of equity moves in the same direction. Now, bond yields for utilities are 250 basis points higher now than they were in case number 9655 when the Commission approved a 955 ROE for Pepco. So logically, if bond yields go up, the ROE should go up, but staff is suggesting it should stay the same. Mr. Garrett and Dr. Keim are suggesting dramatic decreases to the ROE. That doesn't make economic sense. And also, Mr. McAuliffe introduces the concept of gradualism that gets talked about fairly frequently here. In light of the increase in bond yields we've seen, the only meaningful way to implement gradualism is for at least a modest increase in the ROE to reflect those higher capital costs.
Thank you, Mr. McKenzie. Turning to... It is? How about this? Is that better?
Yes.
Okay. Turning to MUA witness Dr. Keim. In Dr. Keim's rebuttal testimony on page 8, lines 8 through 17, he suggests that one of your own sources, New Regulatory Finance, supports his position that the Commission should use market-to-book ratios as a directional signal for the cost of equity. Do you agree?
No, I don't. In fact, the language from this textbook that Dr. Keim quotes in his testimony actually says that the market-to-book ratio of 1 is a lower bound. It doesn't suggest regulators should use market-to-book ratios as a benchmark to evaluate a fair ROE. In fact, it rejects that position. And I'm just going to quote from that book. Are we to conclude that regulators have been systematically misguided all across the United States for all these years by awarding overly generous returns, or are we to conclude that market-to-book ratios are largely immaterial in the context of rate making? The latter is more likely. And this brings up a key assumption underlying both Mr. Garrett's testimony and Dr. Keim's testimony, that regulators have across the country for decades have basically been authorizing ROEs that are dramatically higher than the cost of equity. And I think given the attention that this issue receives in regulatory proceedings, the volume of expert witness testimony from witnesses from various parties that are interested in the outcome, and the professionalism of regulators, I don't believe that this is a logical position to take.
In Dr. Keim's rebuttal testimony at page 8, line 2, he portrays the market-to-book ratio as a, quote, signal. Are there other signals that Dr. Keim ignores?
Yeah, as I just discussed, the bond yield is a primary signal. It's observable. We don't have to debate about it. And it definitely signals that the cost of capital has moved up since early 2022.
And in Dr. Keim's rebuttal testimony beginning on page 11, line 13, he discusses the CAPM, and at page 13, line 4, he suggests that you, quote, mischaracterize the CAPM when it comes to evaluating risk. What is your response to that?
Yeah, I don't agree with his characterization at all. On page 11 of his rebuttal testimony, he actually quotes my testimony and says that risk in the CAPM is proxied by beta, quote, which captures stock price volatility relative to the market. That's my testimony. He then delves into a digression into discussing volatility for individual utility stocks that's completely unrelated to my testimony. And he concludes the beta coefficient, which measures a stock's volatility relative to the overall market, is the right way to apply the CAPM. I use beta to apply the CAPM. Dr. Keim uses beta to apply the CAPM. There's no differences in terms of how risk is accommodated within that model in my testimony as compared with his. And I believe that his discussion about volatility is a straw man that just has nothing to do with my testimony.
And that concludes my rejoinder. And I just wanted to define CAPM for the court reporter's purposes, Capital Asset Pricing Model, CAPM. With that, I will turn Mr. McKenzie over for cross-examination.
No questions, Your Honor.
Okay. Next would be MEA. Okay. Montgomery County is still not here, so we will go to People's Counsel.
Thank you, Your Honor. For the record, Ryan Shu on behalf of the Office of People's Counsel, since I don't think I've spoken yet. Good afternoon, Mr. McKenzie.
Good
How are you doing?
afternoon.
So you have reviewed and are familiar with the direct testimonies of the other witnesses in this case regarding return on equity, including OPC witness Garrett, correct?
Yes,
And you're familiar with the Hope and Bluefield cases, right?
I am.
Could you turn to page 6, lines 6 to 7 of your direct testimony?
Page 6, line 6.
Yeah.
I'm
there. Sorry.
I'm there.
Okay. So here, in reference to the Hope and Bluefield cases, you state that under this doctrine, referring to Hope and Bluefield, the required return is established by investors in the capital markets based on expected returns available from comparable risk investments, correct?
Yes.
Okay. Regarding investors' expected returns, I have an exhibit to hand out if I may approach.
Yeah.
Has OPC, is this their first exhibit? This? Oh, I'm sorry. Okay. That's fine. What is it?
Taylor didn't make it up. Taylor gave you one.
I just want to write it down and then I'll.
Okay, so what I just handed out is a printout from Charles Schwab's public website that I pulled yesterday. There's a URL at the bottom, actually. This was cited in OPC witness Garrett's direct testimony at page 5, lines 9 to 11. The specific printout has a sentence I highlighted myself on the second page. I would like to request this be marked as OPC Exhibit 26, I believe.
So more.
Just one, not necessarily objection yet. I think counsel indicated that this article, this particular article is cited in his ROE witness's testimony. Is that correct, counsel?
Yes.
This article itself?
Yeah. Yes. You want me to repeat the cite line?
Yes, if you could do that, that would be great.
Yeah, it's page 5 of his direct at line 9 to 11, I believe.
Thank you.
Mr. McKenzie, could you turn to the second page in here and just read the highlighted sentence?
We now expect U.S. large cap equities to deliver annualized returns of 5.9% over the next decade, down slightly from last year's outlook of 6%.
And U.S. large cap equities refers to your understanding, would refer to large U.S. companies in the stock market?
Yeah, that would be, I think that would be. Tomorrow, Thursday, right? I'm just looking to see if they actually define it here. Yeah, they define it as the S&P 500, in fact.
Yeah, okay, great, thank you. I would request this be entered into the record as OBC Exhibit 26.
No objection, so entered.
Thank you. So Mr. McKenzie, utilities are low-risk investments compared to companies in a stock market or a competitive market generally, right?
That's generally the case. I mean, if we look at beta, for example, as a risk measure, I think all the witnesses in this testimony refer to beta. And betas for utility stocks are less than the market average of 1, which typically means that they're viewed as a less risky investment than the market as a whole.
And generally, companies that are less risky, investors would require less of a return because they're less risky?
Right, which I think points out a fallacy about this particular article, since you know, a return of 5.9% is, if we were to decide that utilities are less risky than the market, so the return for a utility should be less than 5.9%. 5.9% is already where utility bonds are at, so it doesn't make sense that a common stock investor would expect a return lower than 5.9.
So you're saying that, and if you look at Mr. Actually, do you have Mr. Garrett's direct with you?
I do not.
I could get you a copy.
I'm ready.
So on page 5, line 9 to 11, we have this quotes the statement that we just went over from Schwab. Line 11 through 13, there's also quotes from BlackRock projecting a, 5.2% return, which we're actually going to deal with in the future because I believe the BlackRock has updated that response since Mr. Garrett filed his testimony. And then JP Morgan estimating 6.7%. That's correct?
I see the numbers.
You see the numbers, right? And so are you suggesting that all of these major investors are just flatly wrong?
Well, they all have their opinions, and I have mine. Mr. Garrett has his. The problem with these selected numbers is we don't know a whole lot about what they're applying to. So 5.9% over the next decade, we're trying to set the cost of equity for long-term investment in utility plant, which is perhaps a 50-year investment. The other problem with these numbers is, again, just the fact that they don't really make a whole lot of economic sense when it comes to trying to set the cost of equity for an electric utility. For example, BlackRock projects a smaller return of 5.2%. I can go out and buy a long-term treasury bond yield in the market today for 4.9%. Why would I accept the risk of a common stock when I can get a risk-free investment and get a guaranteed return of 4.9%? I can go buy a utility bond in the market today and earn 5.9%. Again, with a mortgage. It doesn't make sense.
Thank you. Nothing further.
In that case, we'll turn to staff. Oh, no, MEA already said they're not.
Good afternoon, Mr. Chairman and Commissioner Shauna Wilkerson on behalf of staff. I'm going to ask Pepco Council to hand Mr. McKenzie a copy of Staff Witness McCullough's direct testimony at the outset before I get to it.
Counsel, did you say direct?
That's correct. Good afternoon, Mr. McKenzie. You can sit that to the side for a minute. It'll be a couple questions before I get there. Now, Mr. McKenzie, is it correct that you were the return on equity witness in Pepco's last rate case, case 9702?
Yes.
And as Pepco's return on equity witness in that case, Pepco proposed a 10.50 return on equity. Is that correct?
Yes, it is.
And that's the same return on equity that Pepco is proposing in this case. Is that correct?
Correct.
And in case 9702, the Commission chose not to adopt that return on equity. Is that correct also?
Yes, that is correct.
And do you recall the Commission's rationale for not accepting Pepco's proposed return on equity in case 9702?
Well, I read the order. I mean, I think the Commission evaluated the evidence and made a decision that it felt was reasonable at the time. Obviously, I don't agree with it, but that's often the case.
I'm going to hand out the relevant pages from case 9702 because we're going to go down the road of what the Commission said as their rationale in not accepting it. Did you give to the witness?
Yes. Thank you.
Yeah.
Now, Mr. McKenzie, what you've been just had it is a cover page from Order 91181, and that's the top page of the Commission's order in 9702, and relevant pages 148 and 149. If you would turn your attention to page 148, and if you would read for me the highlighted in yellow sentence, just that one sentence that's highlighted in yellow that starts the Commission's finds.
The Commission finds as an initial matter that Pepco's recommended 10.5% cost of equity is unsupported by the record in this proceeding. Pepco's request is a significant increase from its current ROE of 9.55%, does not reflect current capital market conditions, and does not conform to this Commission's gradualism precedent.
And so if we look at the last part of that sentence you just read, does not conform to this Commission's gradualism precedent. Since Pepco has proffered a 10.50 return on equity in this case, is it the company's position that its proposed 10.50 return on equity conforms with this Commission's gradualism precedent?
Well, I can't speak to the company's position. I can speak to my opinion, if that's what you're asking for.
Well, you represent the company in this proceeding, so I'm asking you, is it the company's position?
Well, I'll tell you my position is, first off, I think there's been a lot of talk about gradualism by various witnesses and proceedings over the history of cases I've been involved in Maryland. And I haven't really seen any consistency or even any definition about what's actually being done under the name of gradualism. So, for example, Mr. McAuliffe talks about it in his testimony, but doesn't really say or inform us about how he uses it. I would understand from the Commission's order here that moving from 9.55% to 10.5% is not a gradual move, and I would agree with that. That doesn't prevent me from defending that number as the cost of equity, but I could see an upward move that's less than that full amount as meeting gradualism.
And in this case, Pepco's current return on equity was 9.50, and in this case, they're proposing, or the company's proposing 10.50. So, would you consider that gradualism?
No, I haven't applied gradualism in my testimony whatsoever. I've given the commission my best estimate of what I think the cost of equity is, and I think it's the commission's prerogative to apply gradualism. But as I indicated in my rejoinder, any application of gradualism that would make sense given the high rise in bond yields would make for some sort of an upward move, not a downward move or not staying the same.
Thank you. Now, for a moment, I'd like to turn your attention back to the handout. If you look at page 149 of that handout, it's just on the other side of page 148. And could you read into the record that yellow highlight starting at finally?
Finally, this approved ROE is consistent with the nationwide average of awarded ROEs for electric utilities in recent years and at present, which have stayed steady even as interest rates have fluctuated.
So, based on the sentence you just read, that indicates the commission also took in the nationwide average of awarded ROEs for electric utilities in its decision in case 9702. Would you agree with me on that?
Yes.
Now, I'd like to turn your attention to your rebuttal testimony, schedule AMM-R-13. Let me know when you're there.
I'm there.
And so, at the top of that page, it says National Authorized ROEs. Is it correct that this exhibit AMM-R-13 represents the average return on equity, at line 1 of the exhibit, which reads allowed ROE 2013 through Q3 2025, represents the average return on equity authorized by state regulatory commissions for the period 2013 through third quarter 2025?
Yes, that's right. That period matches up with, I believe, what Mr. McAuliffe referenced in his testimony. Those numbers are now higher. All electric would be 977 for 2025. Distribution only would be 956 for 2025.
And that's where I'm going. And so, what you just read under the line, on line 1, under all electric, that would be all electric utilities, including vertically integrated, correct?
Yes, ma'am.
And under the heading distribution only, that number would be only electric utilities that only service distribution. Is that correct?
That's
a distribution only utility.
That's correct.
Okay.
Transmission and distribution, no generation.
Correct. Now, Mr. McKenzie, you've reviewed the direct testimony of staff witness McAuliffe, is that correct?
Yes, I have.
And you have a copy before you, correct?
I do.
Now, I'd like to turn your attention to page 32 of Mr. McAuliffe's direct testimony at lines 3 through 5. Let me know when you're there.
I'm there.
Now, at lines 3 through 5, Mr. McAuliffe provides information on the nationwide average authorized return on equity of all your electric utilities for 2025. And below that text, Mr. McAuliffe has table 6, which shows the nationwide average by year for all electric utilities for the years 2013 and through 2025. Do you see that?
Yes.
Subject to check, would you agree with me that the average of each year from 2013 to 2025 in Mr. McAuliffe's Table 6 is the same for all electric utilities, that 9.68% that's in your exhibit, Schedule AMM-R-13, subject to check?
Yeah, I can take that subject to check. It should be very close. If it's not, we're using similar sources.
And then if I turn your attention to the next question, starting at lines 8 and 9 of page 32, Mr. McAuliffe provides information on distribution only, the nationwide average of awarded ROEs for electric distribution companies only. And beneath that text, he has a chart that's Table 7. You see that?
Yes, I do.
And similarly, subject to check for the years 2013 through 2025, would you agree with me that the distribution only average of Mr. McAuliffe's table is the same, roughly the same as your distribution only 9.31 in your exhibit, Schedule AMM-R-13?
Yeah, I would agree with that. And one thing I would point out, however, just to the Commission, is that it's important that the Commission recognize that it's apples and apples to look at ROEs from various periods without correcting for differences in capital costs. So I talk about this in my rebuttal testimony, but obviously we had extremely low interest rates in 2020, 2021, and we see ROEs were very low. So those ROEs were set in a period of economic conditions that don't compare to where we are now.
Thank you. Now I'd like to turn your attention to your Schedule AMM-R-12 on the page before the exhibit we were just on. And is it correct that this schedule, your schedule, contains the rate of return approved by the Commission in the last 2 rate cases? Is that correct?
Yes.
And if we look at the first company, which would be Pepco, and column head on 1, we see case 9702, or the numbers 9702, I'm sorry. And column number 1, we see the number 9655 under Pepco. And column number 2, we see 9702. Those would be the case numbers. Is that correct?
Yes, that's correct.
And if we look over to the left-hand side, far left, we see approved ROE. And if we look back to the first column under Pepco 9655, we see 9.55 was the approved ROE by this Commission. Is that correct?
Yes.
And if we look at the approved for 9072, that was 9.50. Is correct?
That's correct. And again, we see that the average bond yield when 9655 was approved was 3.37%. It went up to 5.93%. It's about at the same place today. And I'm just making the point that there's a disconnect between the way bond yields are moving and the way the ROE is moving.
Okay. And the difference between the approved ROEs between case 9655 and 9702, that was actually a decrease. Is that correct?
That's correct, yep.
And Mr. McKenzie, in this proceeding, Staff Witness McCullough is not recommending a decrease in Pepco's ROE. Is that correct?
That's correct. But again, as I point out in my rebuttal, there's a catch-up to be made. I mean, again, if we go back to this concept of gradualism, we've had a 250 basis point increase in the utility bond yield. Costs of capital move in the same direction, just like mortgage rates go up when 10-year treasuries go up, but actually the ROE for Pepco went down. So if there's to be gradualism in this case, it should be going up, not down.
Thank you, Your Honor. Staff has nothing further for this witness.
Redirect?
Yes, just a few questions. Mr. McKenzie, you were handed a copy of the Commission's order in 9702, and there was highlighted information about the underlying reasoning for the Commission rejecting your ROE in that case. Do you recall that?
Yes.
And one of the highlighted items on page 148 said that one of the reasons that the commission did not accept your ROE was it did not reflect current market conditions. Does your 10.5% ROE recommendation in this case reflect current market conditions in your estimation?
Yes, it does. And in fact, one of the things I look at to make the point about the disconnect between current ROEs and current capital costs is to look back in time at allowed ROEs during times when interest rates were comparable to where they are now. So not my recommendations, but what if commissions actually authorized when bond yields are about where they are now? And the average of those ROEs is 10.3. 10.5 is a little higher, but it's not a crazy number. In relation to where ROEs sit today, I recognize it's a big move. But as I point out in my testimony, there's been a fundamental disconnect between allowed ROEs and drivers of cost of capital, namely bond yields.
And do you recall staff counsel asking you questions about Table 6 in staff witness McAuliffe's testimony? And that was the table that had the averages or the average ROE for going back to 2013.
Yes.
And that shows that in 2025, the average nationwide ROE for vertically integrated and distribution-only utilities is 9.71. Is that what the table is indicating?
Yeah, that was not no fault of Mr. McAuliffe. I'm sure the data that he had when he prepared his testimony may have been through the first half of, well, probably the third quarter, given his testimony was prepared in January. So the actual annual averages for 2025 didn't come out until April. And as I stated earlier, those are 9.77 and 9.56 for distribution-only utilities.
Oh, could you restate what that number was for distribution only, the updated number?
9.56%.
And staff's recommendation is below both of those averages for 2025, is that correct?
That's correct.
I have no further questions.
Very well. Then we'll proceed to questions from the bench in the order of Linton, Suchman, Hoover, McLean, and the chair. Commissioner Linton.
Thank you, Mr. Chairman. Good afternoon, Mr. McKenzie.
Good afternoon, Your Honor.
These iPads, things move around sometimes, you don't want them to. I'm on page 5 of your rebuttal testimony. It's figure AMMR1. So this is the clean and red-lined copies. That's the one I'm using from that were filed by the company in late April, I think it was. I just wanted to make sure that the ROE that the company is proposing in this case wasn't changed or revised after the companies decided to proceed under a historic test year model as opposed to the forecasted model that was originally part of the original filing.
No, it was not revised. I delve into the distinctions between historical test years and future test years somewhat in my direct testimony. I point out basically that forward-looking test years are viewed more favorably by the investment community. They're considered to be supportive. Historical test years less so. So there's some comments in the credit rating agency reports about historical test years in Pepco's case, and they're concerned that that could continue earnings attrition, basically an inability to earn the actual authorized ROE.
So is there a reason why your ROE is tied primarily to capital market conditions as opposed to the change in rate making model? So you've got the same number for both. So.
Yes, that's right. And I think basically the ROE is as you said, tied to capital market conditions and ultimately to investors' risk perceptions. So to the extent that the choice of the rate-making model has a material effect on investors' risk perceptions, that could arguably influence the ROE to some degree. Now, in this case, there wasn't any indication when the company proposed the forward-looking test year that there was going to be, let's say, a credit rating upgrade as a result of that, or any other material upward move, downward move in risk. So in terms of making a distinction between the ROE for one case or another, I don't see the basis to do it. I do think, however, if you look at the rate-making mechanisms that the companies in the proxy groups have, their ability to use multi-year rate plans, forward-looking test years, all those things help give confidence to investors that the company can better earn its ROE. So I think going back to a historical test year is a negative, but I don't think it's negative enough to cause me to adjust my ROE evaluation.
All right, thank you. That's all I had, Mr. Chairman. Thank you, Mr. McKenzie.
Commissioner Suchman. Commissioner Hoover.
Thank you for getting. So, in your discussion with the representative from the Office of People's Counsel, you talked about the fact that utility stocks are considered to be a safer investment than stocks across the board.
Correct.
And that's even more true for a company like Pepco, which is a subsidiary of one holding company, PHI, which is then a subsidiary of an even larger holding company, Exelon. So wouldn't that make them even less or more safe than say, Acme Utility, that may be a standalone company?
Yeah, I mean, there's certainly some benefits both to customers and to shareholders from having a larger entity. So you have greater scope, you have greater efficiencies, you have, at least at the Exelon level, you have regulatory diversification, you have economic diversification over different service territories. But we're not setting the cost of equity for Exelon. So the analysis, we typically have to use these holding companies as the basis to estimate the cost of equity, but what we're really trying to do is focus in on Pepco's Maryland jurisdictional electric utility operations. So the fact that, for example, there isn't regulatory diversification here. Pepco has a little bit because it has some operations obviously in DC. But it's not the same as, say, at Exelon. So I don't think there's an automatic risk adjustment. I think if you look at credit ratings, for example, you do see that reflected in Pepco's credit ratings, which is what I used to develop the proxy group. So they're rated a notch higher than Exelon. So again, it's specific to Pepco. It's not at the Exelon level.
Okay, but as opposed to competitive companies, I mean, Pepco is in a situation where they have a process for recovering the expenses that they make, different from a competitive company, which is just reliant on people buying their product.
Right.
And you're concerned about the historic test year. I mean, I think it's fair to note that the decision that the company made to file the historic test year was not based on anything that was done by this panel, but was in reaction to actions by the Maryland General Assembly in passing legislation, correct?
That's my understanding, yes.
Okay. I guess the last question I got is, given the current economic situation and world events, I mean, isn't the risk area for competitive companies even higher than it would be for a company that is rate regulated and has a process for getting recovery of its expenses?
Well, again, I mean, I think there's pros and cons to regulation. So Pepco can't change its prices whenever it wants to. It can't withdraw from certain markets, portions of the city, if it doesn't feel like it's earning a sufficient return. It has to provide service. So it's a dual mandate. There is an agreement that Pepco will serve everybody with reliable service, and it will be subject to having its prices set by the commission. In terms of risk, regulation doesn't remove the risk, certainly to stockholders or to cost recovery. So, for example, there was a lot of talk about a substation recently. There's been, over the last several years, an inability for Pepco to actually earn the authorized return. So the 9.5 or the 9.55 that the commission sets is not a guaranteed return.
So I realize that you're here, on behalf of the company and trying to reflect the concerns that you think, need to be, we need to consider when it comes to investors. But the flip side of that coin is the folks that are actually paying the rates, the customers, and in particular residential customers. And so amongst the items that they have to pay in their daily budget, this is the only item of significant expense that has any sort of governmental regulation. Isn't that true? Gasoline, food, housing. I mean, none of those things have any sort of governmental regulation when it comes to the price, correct?
Right. Yep, I'd agree.
Okay. All right, that's all.
No questions, sir. Thank you.
Thank you.
One or two questions from me. First of all, in this discussion, you've mentioned the concept of gradualism, but gradualism is not just a concept that's applied to Pepco or to BG&E or in Maryland. It's a national concept, is it not, in rate making?
Well, gradualism as a concept in rate making traditionally has referred to customer cost allocation. So it more often in other jurisdictions, I see it referenced where we're trying to decide whether to move one class closer to its cost of service, and try to balance out those diverse interests between, let's say, commercial and residential customers. And the notion is that we don't do that all in one fell swoop. So if we do our cost allocation and find that based on current rates, one class is paying significantly more than its cost of service and another one's being significantly subsidized, we don't move those all in one fell swoop. But in terms of the ROE, honestly, I haven't seen any other jurisdiction where gradualism is referred to in the context of ROE, but I think, to your point, I think implicitly it is recognized because we don't see large swings in allowed ROEs. It's the battleship turning.
Well, and I, since having this job for 3 years, I talk with my colleagues across the country, and do you agree that the general attitude with respect to gradualism is that the end result of the rate making process ideally should not have wild swings, and that really ROE and everything we do here, discussing specific projects, these are all variables that feed into the ultimate residential rate, correct?
Right, and I would agree with your point about wild swings, and I think, but I think at the same time, I think it's important not to lose connection with basic economic principles, like the connection between bond yields, which are observable, which we can see, which we don't have to argue about, and the cost of equity. So I think when there's a disconnect, that's when investors get especially rattled.
So I actually don't know from reading your documentation. Do you have any experience in wealth management? Do you advise wealth managers, or is that?
I do not.
You do not. Okay.
No.
Let me tell you the reason I asked that question. When a portfolio is being put together for an individual, it's a very diverse portfolio. There are going to be managed futures, fixed income investments, and various different types of equity investments, blue chips, small cap, medium cap, and all those things. My understanding of the the place of utility investment is, I'm not going to say it's like buying a T-bill. It's not that stable and stodgy, but it's in the spectrum of investments, it's closer to that than it is to small cap equities. Would you agree?
Yeah, I don't know in terms of closer to T-bill, but I don't have any problem. We can all agree utilities are defensive stocks, and typically in times of risk-off behavior, for example, utility stocks can become more popular. But I think it's also important to recognize that the outlook for utility stocks is also shifting with the changing dynamics in the economy. So we're now seeing a lot of investors looking at utility stocks as a backward way to get into the tech business through AI investment, data center growth. And so if we don't want to take the full risk of that, we'll maybe get it through this.
You're going exactly where I wanted to go, and that is that right now a lot of investors are looking at electric utility investments as a safe way to get into that market. So I guess you've made the point that I was going to ask you to make. I think
but if I could just say one more thing, I think
Sure.
it's important to consider that the driver for that is growth expectations. So investors are seeing growth as the basis to invest in the stocks.
Okay. Well, I don't have any more questions, so thank you very much.
Thank you.
Well, only 4 o'clock. Lucky us.
And Mr. Seegers will be calling our next witness.
Okay.
Yeah.
I've packed my trash. Okay. Thank you.
Council?
Adrian, it's always nice seeing you. Have a safe trip home. Okay, man. Had fun.
Thank you.
There'll be a next time.
You think?
Yeah. You're heading to Austin.
Yeah.
Okay, have fun. Maybe go to Antone's and hoist one.
Man, Antone's doesn't. I don't even think it exists.
Real? I haven't been down there in
Yeah.
quite some time.
There's all sorts of other alternatives.
Oh, don't I know it? No, I do not. Are you sure?
Yeah, good to see you. How you been? Yeah, I was
keeping busy?
Well, you can say.
As usual.
Yeah, it's good to be busy. Not too busy, but just.
Yeah, no,
just
man.
enough, right?
Don't let any grass grow under your feet.
Yeah. At least I don't have to handle cafe.
I'm missing you.
There's many more years to come, right? Maybe hopefully not as many for you.
Okay, well, I actually hadn't intended to take a break.
But
Where is everyone?
they're taking a break.
Look, do you want me to take a 5-minute break? Do you need to organize? What's going on?
Your Honor, if I...
That would be helpful, Your Honor.
Okay.
The Office of Counsel may have a proposal for
Whoa. Well, in that case, you might earn.
Take as long as you want.
Yeah, you got 10. You got until 5 minutes after 4.
Thank you.
discussing it, Your Honor.
We tried.
Okay, let's get started here.
Good
Proceed.
Good afternoon, Mr. Chairman. The company would next like to call Mr. Connor Nelson to the stand.
I do.
Good afternoon, Mr. Nelson.
Good afternoon.
Could you please state your name and your business address for the record?
Connor Nelson, 701 9th Street Northwest, Washington, D.C. 20068.
Okay. Do you have before you your pre-filed direct testimony submitted on behalf of Pepco in this matter consisting of 31 pages and 4 exhibits?
I do.
Do you have any corrections or modifications to this testimony at this time?
I do.
And what would those be?
Yes, so starting on page 14 of my direct, lines 8 through 10, striking during the course of the proceeding, the company will provide actual quit balances reflecting the known and measurable already incurred supporting TTYCF RMAs 3 and 4.
And what's the change?
Just striking that.
Striking that, okay.
Next. Good. Page 15, line 14, it says, why is the FFTY RMA 5? That should be, strike that for TTYCF. Next page, page 16, line 14, striking case number 9702 rate case costs and replacing with Maryland Electric Vehicle and Battery Energy Storage System, BESS, in parentheses, regulatory assets. Next, page 20, line 22. It says 2024. Strike that for 2025 to replace. And the final one, page 29, line 6. It says FFTY RMA. Strike to replace with TTYCF.
And with those corrections, Mr. Nelson, if I asked you the same questions today, would your answers be the same or similar?
They would.
Your Honor, I would like to have Mr. Nelson's direct testimony marked for identification as Pepco Exhibit 26.
So marked.
We're up to. Mr. Nelson, do you have before you your pre-filed supplemental direct testimony submitted on behalf of Pepco in this matter, consisting of 7 pages and 2 exhibits?
I do.
Do you have any corrections or modifications to this testimony at this time?
I do not.
And if I asked you the same questions today, would your answers be the same or similar?
They would.
Your Honor, I'd like to have Mr. Nelson's supplemental direct testimony marked for identification as Pepco Exhibit 27.
So marked.
Mr. Nelson, do you have before you your pre-filed rebuttal testimony submitted on behalf of Pepco in this matter, consisting of 47 pages and 2 exhibits?
I do.
Do you have any corrections or modifications to this testimony at this time?
I do not.
And if I asked you the same questions today, would your answers be the same or similar?
They would.
Your Honor, I would like to have Mr. Nelson's rebuttal testimony marked for identification as Pepco Exhibit 28.
So marked.
And Mr. Nelson, do you have before you your pre-filed surrebuttal submitted on behalf of Pepco in this matter, consisting of 2 pages and 1 exhibit?
I do.
Do you have any corrections or modifications to this testimony at this time?
I do not.
And if I asked you the same questions today, would your answers be the same or similar?
They would.
Your Honor, I'd like to have Mr. Nelson's surrebuttal testimony marked for identification as Pepco Exhibit 29.
So marked.
And at this time, Your Honor, I would like to move into evidence Pepco Exhibits 26, 27, 28, and 29.
Without objection.
Mr. Chairman? I'm sorry.
No.
Staff would like to ask Pepco to please clarify 26, 27, 28, 29. We'd like the ML numbers and the date that they were pre-filed for each one of those exhibits.
I'm not sure if I... Do we have that? Not sure if I have the case log here, but each one of them was pre-filed, so... Do you have the case log? Okay.
That's true.
Yes, these are all the same.
This takes a while. Why don't you ask Ruthie if she's going to let them email it to her later?
Ms. Herman,
Sir?
if this takes a while, would it be acceptable to have them get back to us?
Of course.
Okay.
And I'm sorry, if it provides any clarity, Your Honor, Mr. Nelson's, all of his testimonies were refiled with all of the other testimonies that were submitted on Friday. However, there was nothing removed from Mr. Nelson's testimonies. So they were the same as they were originally submitted. We'll be happy to provide those mail log numbers as well, but there's been no change to Mr. Nelson's testimonies.
Err on the side of more information.
Absolutely, sir.
Okay, and so therefore, without objection, so entered.
Okay, thank you. And I would ask for leave to conduct some live rejoinder of Mr. Nelson.
Proceed.
Thank you. Good afternoon, Mr. Nelson.
Good afternoon.
Have you had an opportunity to review the surrebuttal testimonies of Staff Witness Riley, OPC Witness Madsen, and AOBA Witness Bruce Oliver regarding the company's proposed treatment of rate case expenses in RMA 10?
I have.
And could you please summarize the position of Staff Witness Riley?
Yes. Staff Witness Riley aligns with the company from a cost recovery perspective with regulatory asset treatment with a 3-year amortization. Where he divorces from the company's proposal is disallowing any return or inclusion in rate base associated with this deferred regulatory asset.
Okay. And do you agree with this treatment?
No, I do not. I believe, consistent with commission precedent, to the extent that the costs were deferred to a regulatory asset, considering the financing and over the amortization for the 3-year period, the full return should be allowed.
Okay, and the way that the company is proposing their rate-making treatment, has that been previously approved by this commission?
Yes. In cases 9443 and 9418, the commission precedent was to allow regulatory asset treatment with a full return. Most recently, in case 9602, there was expense treatment afforded to the company. Which the company is not necessarily opposed to, but in light, from an affordability perspective, believe the regulatory asset treatment is the best. I would note that nowhere in commission precedent has the commission approved a regulatory asset without the return.
Okay. And could you please summarize the position of OPC Witness Madsen regarding RMA 10?
Yes. Witness Madsen opposes the rate-making adjustment on the grounds that the company's proposal initially included an FFTY and TUTYCF within the proposal.
And do you agree with OPC Witness Madsen?
No, I do not. These costs that were incurred in the preparation and development of this case, and reasonably incurred, were in accordance with the order in case 9702, where the commission stated that they afforded that the next rate case filed by the company could be any of their choosing. It just needed to include the requisite information to calculate a historic test year, which the company has complied with.
Okay. And has the company provided known and measurable costs associated with RMA 10?
Yes, we have. So consistent with how this rate-making adjustment has been approached, most recently in 9602, the company has provided actual invoices as we've gone through this proceeding, as well as executed contracts that support these known and measurable costs. I think we most recently provided an update in staff DR 48-14, I believe.
Permission to approach the witness, Your Honor?
Granted.
Mr. Nelson, I've handed you the company's most recent update to staff DR 4814, a portion of which is confidential. Is this the DR response that you just referenced?
It is.
Okay, Your Honor, I would like to have this exhibit marked as Pepco Exhibit 20. What number are we up to? 30. And
You're right,
30. And a portion of this is confidential, so
C?
30C.
For the whole thing or just for the confidential part? I mean, it's, I don't care.
30C would be perfectly fine, Your Honor.
Okay.
And
Your Honor, if I could just ask, I think the information on attachment A, page 2 of 2, and page 1 of 2, that should be in the public record. So OPC suggests that attachment B to this DR be Pepco Exhibit 30C, and Pepco Exhibit 30 be the DR response and attachment A.
we have no objection to that, Honor. What we can do is make the first.
Well, hold on. I want to make sure I understand exactly what OPC is saying. What do you wish to have be public, and what do you wish to? It got scrambled in my mind.
Yeah,
So.
happy to explain, Your Honor. So attachment A kind of provides invoice, a list of invoice amounts by date, and sums up the total rate case costs that Pepco is seeking to recover. OPC believes that should be in the public record, but as for the invoices themselves, OPC is fine with those being kept confidential.
Okay. So, all right. Do you agree to that?
I believe so, Your Honor. Yes.
Okay.
So we can label the first part, the actual response, as well as attachment A. That can be Exhibit 30, and then attachment B can be 30C.
Okay.
And I would ask for Pepco.
So marked. And do you want to enter it?
Yes, we would like to enter it into the record.
So, okay. And,
Mr. Chairman?
Yes.
We'd like to know the date on that response that they just passed around. What was the date that was submitted to the parties?
It's right on the cover. Updated response, April 23rd, 2026.
Thank you.
You're welcome.
Okay. Without objection, so entered.
Thank you. Mr. Nelson, are you able to summarize the position of AOBA witness Bruce Oliver regarding RMA 10?
Yes. AOBA witness Oliver questions the use of external consultants in relation to these rate case expenses.
And do you share Mr. Oliver's concerns?
I do not, no. The use of external consultants is a common practice in the industry. I would say, using an example, the rate design and class cost of service are highly technical and critical needed in this proceeding. And so the expertise the expertise and the innate understanding of Pepco case dynamics is extremely important and was taken under consideration when we engaged the consultants. They also, with practicing with other clients, bring innovative rate design topics and other items that can contribute to the value, and the use of these external consultants contributed not only to the continuity but the consistency of presentation as well as the timely preparation in this proceeding.
Okay. Changing topics, OPC witness Madsen proposes to reduce the company's rate-making adjustment attributed to its annualization of wage increases relating to RMA 20. Can you please summarize his approach?
Yes. So OPC witness Madsen disconnects from the company's proposal. Instead of using test year data as the basis for this adjustment, he uses calendar year 2024 data. He does not provide a reason for this disconnect. Additionally, he omits PHI service company labor and BSC labor that is incurred down to the Pepco Maryland cost of service level, which has historically been included and approved by the Commission.
And the company's proposal for RMA 20, has that previously been approved by this commission?
Yes, it has. To the extent that the costs were known and measurable, this has been approved most recently in case 9602.
Okay. Staff witness Riley, disagrees with the validity of the company's annualization of test year property tax increase in RMA 26. Can you please summarize his concerns?
Yes, so staff witness Riley's basis for disagreement here is the fact that fiscal year 2026, the period of July 25 through June 26, overlaps with the test period in this proceeding, which is October 2024 through September 2025. So there's 3 months of overlap.
And do you agree with his conclusion?
I do not. The validity of this rate-making adjustment is predicated on a fiscal year 2026 property tax assessment that is known and measurable, that the company is already incurring costs associated with this. And so this adjustment is really meant to compare test year property taxes with the cost of property taxes that we will be incurring in the rate effective period and already are incurring. So any overlap just really affects the magnitude at which this adjustment is needed, not necessarily the need in general for this adjustment.
And the company's proposal for RMA 26, has that previously been approved by this commission?
Yes, it has, most recently in case 9602.
Okay. Has staff witness Riley raised any concerns regarding the allocation of certain RMA2 post-test year safety and reliability plant closings?
Yes, staff witness Riley raised issue with identification and jurisdictional allocation, I believe, of subtransmission and general assets.
Okay. How are these general and subtransmission projects allocated with respect to RMA2?
Yeah, so at this point, RMA2 represents all actual known assets that are providing benefits to customers. They are allocated consistently with the jurisdictional cost of service and longstanding commission precedent.
Okay. Have any other witnesses, have they commented on the company's jurisdictional cost of service methodology?
Yes. Importantly, staff witness Lee has noted that he has found no issues with the jurisdictional cost of service, and he found it reasonable and reliable for use in this proceeding.
And are you able to provide any additional insights as to the mechanics with respect to updates to RMA2?
Yes. So consistently with the approach that we took in case 9602 and other historical cases, this rate-making adjustment started out October 2024 through March 2026, all projected plan additions. As we've progressed through this proceeding, we've updated it with actuals. I will say that as of I believe it was sometime early March 12th is sitting in my head, maybe March 13th, we had updated 5 months of actuals to be reviewed by parties. I think we subsequently updated April 13th with the final month of actuals, so that RMA2 is completely consists of actuals. This timing was mirrored the timing that was afforded in case 9602, which again, this rate-making adjustment was approved by the commission.
And Mr. Nelson, were you present earlier in the hearings when staff was questioning the allocation methodology within staff DR6 relating to RMA2?
Yeah, I think it was staff 56. If I remember correctly, I was present. Part of the discussion was really around RMAs 2, 3, and 4, and there was a noted correction that was outlined in that data request. This correction was isolated to the projected plant additions included in RMAs 2, 3, and 4. As I stated earlier, at this point, RMA 2 is completely actual plant additions providing benefits to customers, and those plant additions are allocated consistently with the J-costs and following long-standing commission precedent. So just to reiterate, isolated specifically to the projections was the correction that was made. And if I may, additionally to that, there was a discussion around projects that had DC in the naming convention. I think there was a little bit of a discussion and back and forth, not only with witness Lemming, but witness Allo as well, to the extent that these projects were general or subtransmission. Okay, sorry. To the extent they were general subtransmission, they benefit customers in both jurisdictions. I would say as there are assets that have the net naming convention DC and are allocated across jurisdictions, there are projects that have Maryland and are allocated across jurisdictions, benefiting both sets of customers as well.
And Mr. Nelson, is the company's proposed rate-making treatment for RMA2, has that previously been approved by this commission?
Yes, it has. This rate-making adjustment has been consistently included by the company and approved by the commission, most recently in 9602.
Okay. Mr. Nelson, do you have any concerns with OPC witness Madsen's proposed operating revenue adjustment to the company's traditional test year compliance filing?
Yes, a couple items to note, and I believe this was covered by company witness Lemming earlier in this proceeding. He noted that the narrative and the basis for this revenue adjustment of a 2% load growth is contrary to again, the narrative that OPC has been pushing through different presentations outside this immediate forum, where they question the uncertainty of load growth as well as PJM's projections. In addition to that, and I think the exhibit that was referenced earlier by company witness Lemming was RTL R-2-4, where it's had PJM or a presentation that referenced a load growth of 2%, again, the basis of this adjustment, but the fact that that's on a 10-year load ramp. So I think it really showed in this graph that the load didn't really materialize until post 2030, which is well outside the rate effective period in this proceeding.
Would OPC's hypothetical load growth actually result in an increase in the company's commission authorized revenues under the bill stabilization adjustment or the BSA?
It would not. The BSA disconnects any increase in consumption with the revenues that the company has been authorized to collect by the commission. So any increase would not materialize to the level of revenues that are included in this one-sided adjustment.
Okay. Does OPC witness Madsen's proposed operating revenue adjustment conflict with any key or fundamental rate-making principles?
Yes, it does. It neglects the matching principle. And so when you talk about how this 2% load growth would be facilitated, it does not take into account any of the capital investment or associated operating expenses, depreciation, property taxes that would be needed to facilitate this load growth. So as I said before, this is a one-sided adjustment really targeted at reducing the revenue requirement.
Okay, and last topic, I believe, Mr. Nelson. How do you respond to AOBA witness Bruce Oliver's concerns with the company's kayak accounting?
So my immediate response, I know as has been said already, the company is compliant with generally accepted accounting principles. We are in conformance with regulatory accounting standards. We are publicly and independently audited by PricewaterhouseCoopers, and I am not aware of any issues that Pricewaterhouse or any other parties in this proceeding have identified as a result of our kayak accounting.
Could you please summarize AOBA witness Bruce Oliver's adjustment to cash working capital as it relates to the inclusion of kayak?
Yes. AOBA witness Oliver suggests that kayak should be contemplated in the calculation of the cash working capital component in rate base.
And do you have a response to witness Oliver's claims regarding kayak inclusion in cash working capital?
Yes, I disagree with this the thought pattern. Kayak is really an earmarked customer contribution to capital projects and meant to reduce gross plant and any associated return or depreciation that would come from that otherwise. To consider kayak in the cash working capital, similar to how other general liquidity is addressed, would effectively be double counting the ability for these funds to be contemplated in cash working capital and again to offset any of that capital investment.
And finally, Mr. Nelson, is the company's cash working capital, is that supported by a commission-approved lead lag study?
Yes, it is. The company last submitted a lead lag study in case 9702, which was approved by the commission.
Thank you very much, Mr. Nelson. The witness is available for cross-examination.
Very well. We'll start with AOPA.
Your Honor, OPC is going to go first with this witness, if that's all right.
That's fine with me.
So, Actually, I was going to pass it to MEA, but I'm happy to go first if you would prefer, Your Honor.
I'm happy.
Or you could draw lots. I don't care. Whoever wants to go first is first. You know.
We'll just go down the line.
Okay.
They could wave.
Sorry, Mr. Seegers. Good afternoon, or I guess almost early evening, Mr. Nelson.
Good afternoon.
So I'd like to talk a little bit today about the rate-making adjustments 3 and 4, and then I'll have a few questions for the exogenous cost regulatory asset towards the end. So in your testimony,
And this is direct or rebuttal, sorry.
this just generally the testimony.
Okay.
Yeah, I'll give you a specific reference when the time
Fair enough.
comes. So just your testimony presents rate-making adjustments relating to post-test year reliability plant closings, right?
That's correct.
And two of these adjustments, rate-making adjustment 3 and rate-making adjustment 4, are based on projected reliability plant closings from April 2026 through July 2027. Is that right?
Sounds right, yes.
You're familiar with the concept of a forecasted test year, is that correct?
I am.
And you'd agree that under a forecasted test year, rate base reflects plant closings forecasted during the forecasted test year period. Is that correct?
Can you restate the question?
Sure. So under a forecasted test year, the rate base for that test year period reflects forecasted closings to plant. Is that correct?
I would generally agree with that.
And you'd agree that for rate-making adjustments 3 and rate-making adjustment 4 to the traditional test year compliance filing, these adjust the historic test year rate base to account for forecasted closings to reliability plan. Is that correct?
Yes, I would say that these are rate-making adjustments that are attempting to align plant more with conditions that will exist in the rate effective period.
But the closings themselves are forecasted. Is that correct?
That is correct.
And they're forecasted through July of 2027. Is that correct?
That sounds correct. Can you point me to in my testimony where I state that?
Well, you say it repeatedly. Just give me 1 sec. Yeah. I had a PDF issue on the computer, Your Honor. But yeah, PDF direct page 13.
Can you restate your question?
You'd agree that these two rate-making adjustments reflect forecasted plant closings through July of 2027. Is that correct?
Correct.
Okay. And so these two rate-making adjustments, like the FF2I proposal that Pepco has withdrawn, these adjustments would essentially result in customers paying for costs related to forecasted capital additions. Is that correct?
I think, well, I'll say, yes, these are forecasted plant additions. I would say that by the time rates are in effect, some of these assets will be placed into service, so some will be actual investments.
You said some. Are all of these going to be actual? Will all these investments that are forecasted be placed into service?
No.
No? Okay. And do you recall the forecasted test year period duration? The test year that Pepco withdrew?
I believe it was January 1, 2026 through December 31st, 2026, subject to check.
And so that would be a 12-month period?
Yes, that's correct.
And that's 12 months of forecasted plant additions at the time that Pepco filed the case, correct?
Correct.
Okay. And for the traditional test year compliance filing, the test year period ends on September 30th, 2025, correct?
Can you restate that, please?
What year does the traditional test year compliance filing test year period end?
September 30th, 2025.
So in this case, is it correct that Pepco is asking the commission to incorporate adjustments to the historic test year that extend 22 months beyond the test year period?
Subject to check.
Does that sound historic to you?
I would say it is a form of rate making from a historic precedent standpoint where we have included adjustments similar to these where for safety and reliability purposes customers would be benefiting, and I said for some of these investments we've included our best guess as to when the rest of the investments are included, and again a lot of these are customer and reliability focused, which is paramount these days.
Are you aware of any commission order approving post-test year plant additions that reflect such a lengthy period of time beyond the test year period?
Can you define lengthy amount of time?
Let's say 22 months.
No, I'm not.
Okay. Trying to make sure I have the right site for you. Apologies for the delay. Okay, sorry about the delay there, Mr. Nelson. So in your view, and I think you've said this, but if you could just reiterate your point, what's the intended purpose of a post-test year reliability plan adjustment?
So I think in the company's opinion, and mine as well, the need and the reasoning for these post-test year adjustments are to better align the conditions that will exist in the rate effective period, and similar to the matching principle, the associated revenues with the costs that the company will incur.
If you could turn to your rebuttal testimony at page 25, and I'll take a look at lines 10 through 12.
25, you said?
Yeah, that's correct.
Lines what? Sorry.
10 through 12. And here you state that the commission has not approved post-test year reliability rate-making adjustments where actual plant additions were not provided to the parties prior to the evidentiary hearings. Is that right?
That's correct.
And to your knowledge, is this because in a historic test year, adjustments to the test year must reflect known and measurable expenses?
I would agree that that has been the standard, known and measurable, correct.
Is it your position that all the forecasted plant closings reflected in rate-making adjustments 3 and 4 are known and measurable?
Yes, I would say to the extent that these safety and reliability projects have been incurring capital expenditures over this time, they're known that at some point there will be plan additions related to these projects. From a measurable standpoint, we've included the best estimate that we have as far as the projected in-service dates of these projects.
So just to be clear, you stated that you know at some point the plant will go into service.
Correct.
You don't have you've anticipated when that date might be, but that specific date when plant will close and project will be used and useful, that's not known to the company currently.
Can you restate that question?
So for each of the plant additions that you've talked about, or that you're referencing in these rate making adjustments, does the company know the specific date that it will go into service?
We do have included our best guess, so we do not know the specific date, to answer your question.
Now, if you could refer to lines 13 through 17, still on page 25. Here you state that the company is willing to true up any variances between projected amounts and actual amounts.
I see it.
So if the costs in rate-making adjustments 3 and 4 are known and measurable, why would a true-up be necessary?
I would say to the same extent we included costs for rate-making adjustment 2 and provided those updated amounts to be more reflective and more accurate actuals, we would be willing to do the same here.
But rate-making adjustment 2, as you stated during the rejoinder, as of today, we have all the actual plant additions that the company that are close to plant on the company's books. Is that right?
RMA2 is completely actuals, yes.
Okay. So this true-up proposal, it sounds like a form of reconciliation. Would you agree?
I could see how you get there.
I'll take that as a yes. Now, you're aware in this proceeding that parties raised concerns with Pepco's ability to accurately forecast. Is that correct?
Sorry, can you repeat that?
Are you aware that in this proceeding, parties raised concerns with Pepco's forecasting ability?
Yes, I am aware of that.
And are you familiar with witness O'Donnell's testimony?
Vaguely, yes.
Okay. So I'd like to ask you your opinion about something that she said in her testimony. And this would be in her rebuttal at page 15, line 6. I don't have a copy of it on me, but if counsel has a copy of Ms. O'Donnell's testimony available.
This is the rebuttal, counselor?
That's correct.
Did you state a page, sorry?
Yes, yeah, page 15. And I'm going to be asking you about the answer to question 22.
You already talked that the projects have DC.
Can I read this Q&A?
Yeah, go for it.
Okay.
Okay. So you would agree that in the response to question 22, Ms. O'Donnell is responding to staff witness Riley's testimony regarding the accuracy of Pepco's forecasting?
I see the Q&A, yes.
Okay. Now, could you, if you turn to page 16, could you read out lines 6 through 10 for me, starting with the sentence that begins the dynamic environment.
The dynamic environment in which the company operates is shaped by a range of internal and external factors, some of which can be mitigated, while others represent acceptable and necessary deviations from the original plan.
Continue to the next sentence, please.
In other words, a variance, particularly an overspend relative to budget, generally reflects changes in conditions and prioritization rather than flawed forecasting.
Okay, thank you. So, would you agree with me that here Ms. O'Donnell's testimony is acknowledging that sometimes Pepco deviates from its projections?
Your Honor, I'm going to object. This witness should not be opining on what another witness meant in their testimony. Ms. O'Donnell is going to be taking the stand later on in this proceeding. Counsel is free to ask her these questions.
If I may respond, I'm just laying a foundation for a question specific to the witness, and I want to make sure the witness and I are reading the same sentences.
Sustained.
In your, as you understand it, does Pepco operate in a dynamic environment?
Yes, I would consider the utility industry a dynamic environment.
And as you understand it, is this dynamic environment shaped by a range of internal and external factors?
I would agree with that statement.
And you'd also agree that sometimes these internal and external factors, the effects of those can be mitigated, but in other times the company might have to deviate from its initial plan. Do you agree with that?
I would agree there are a variety of factors that can affect our business that can be in or outside of our control.
And if the company has to deviate from its plan, could such a deviation affect the timing of the company's plant closings?
To the extent there were factors, whether internal or external, outside of the company's control, yes, they could affect the timing of the plant closing, I believe was the question.
And if the timing of the plant closings change, then could the plant and service balance during a rate effective period also change?
Yes.
And the possibility for such deviations, is that why Pepco's proposed a true-up for RMAs 3 and 4?
I think in the best effort to get the most reflective plant additions into the record and contributing to the electric plant and service balance, we were amenable to providing this update similar to RMA 2. Again, your words as a reconciliation.
And given the potential for such deviations, is it still your testimony that RMAs 3 and 4 reflect known and measurable expenses?
Yes, my testimony still is these are known investments that will occur and are ongoing from a capital expenditure standpoint. And they are measurable to our best estimate that we've included in the forecast.
Okay. Are you aware of the Commission's standard rate-making practice relating to post-test year adjustments to plant and service?
Can you restate that question?
Are you aware generally of the Commission's, for historic test year, are you aware of how the Commission has treated post-test year adjustments to plant and service?
I believe I am.
Okay. So would you agree that the Commission considers post-test year adjustments an exception to traditional rate-making practices?
Can you point me to the testimony where it says that?
If I may approach the witness, Your Honor.
Yes, please.
So did you take a look at the paragraph? Well, first, Your Honor, I passed out a copy of the Commission Order 88177, issued in case number 9418. And this order, this portion of the order discusses a rehearing request from Potomac Electric Power Company regarding post-test year reliability plant additions. Mr. Nelson, would you agree that the last sentence of the Commission's decision on that issue states, therefore, we affirm our decision not to grant a post-test year reliability spending exception?
Yes, I agree with that. That last sentence states that. Reading in the above where it talks about the need to depart from traditional rate-making principles at this time, I would say that, you know, in the previous or recent historical cases, we've seen the Commission approve post-test year reliability plan additions, and the value that comes with that in mitigating against regulatory lag and some of the benefits that come from less regulatory lag.
But you would agree that here the Commission's referring to post-test year reliability spending as an exception?
I read the word exception, yes.
To your knowledge, does the Commission always approve adjustments for post-test year reliability plant?
To my knowledge, the Commission has historically approved post-test year reliability plan additions related to safety and reliability up through hearings.
Okay. And if you could turn back to page 25 of your rebuttal testimony at line 19. This sentence here, you refer to the Commission.
Sorry, give me 1 second.
Yeah, go for it.
25, you said, of rebuttal?
Yeah, 25 of rebuttal on line 19.
I'm there.
So the sentence starting on line 19, you'd agree here that you're asking, you're noting that the Commission has approved other post-hearing adjustments when those adjustments were necessary to align rates with conditions during the rate effective period, such as an annualized wage increases in case number 9418. Is that correct?
That's correct.
Are you familiar with case 9418?
Vaguely.
Vaguely. So subject to check, do you agree that in that proceeding, Pepco requested an adjustment for post-test year reliability plant closings dating more than a full year beyond the forecasted test year period and 4 months after the close of the evidentiary hearings?
Can you restate that?
Let's do it this way. Your Honor, if I may approach the witness.
Please.
So, Your Honors, I just passed the witness a copy of the commission's initial order in case number 9418. This is order number 87884. Mr. Nelson, could you turn to page 4? And you'll see there where the post-it is, there should be a sentence that starts with the company used. Could you review that sentence and let me know when you're finished?
Just the one sentence?
Just the one sentence.
I'm done.
So you'd agree that could you confirm that the order states the company used a 12-month test year ending December 31, 2015?
Yes.
Okay. Now, if you could turn to page 10, that should be the next post-it on there. And review the first full paragraph on page 10.
Starting on the previous page or the first paragraph?
Starting on page 10, it should be the first sentence is, the commission held evidentiary hearings.
Got it. Yep.
So can you confirm that this order states the Public Service Commission held hearings from September 13th through the 22nd of 2016?
Yes.
If you could turn to page 30 of this order and review the first full paragraph. It begins with the word third.
I've read it.
Could you confirm that in this paragraph of the order, the commission states that Pepco RMA3 reflects reliability projects forecasted to be placed into service from September 2016 to October 2016?
Yes.
And September 2016 to October 2016, given the prior portion of the order you just reviewed, that's after the evidentiary hearings in that proceeding?
I'd say there's some overlap.
Okay. Now, if you could review the next paragraph on page 30, it begins with the word last.
I've read it.
And could you confirm that this paragraph discusses that RMA 4 reflects additional known reliability projects forecasted to be placed into service by year-end December 2016?
Yes.
So would you agree with me that in case number 9418, Pepco proposed post-test year reliability adjustments dating for more than 1 year after the conclusion of the test year and 4 months after the close of the evidentiary hearings?
Yes.
Do you recall the commission's initial decision on that request?
The decision in case 9418?
Yes, in the order that is right before you. And the decision that you cite in footnote 8 in your rebuttal testimony.
You want me to read it, or?
I can, if you want to turn to page 36. It should be the paragraph in the middle of the page that starts with the word several. Could you read that aloud?
Several parties have pointed out that RMA 3 and 4 do not meet the Commission standard for known and measurable and reliability plant additions being proposed are not currently used and useful for the benefit of current customers. You want me to continue?
Yeah, please read the next sentence.
In keeping with our historical treatment of similarly proposed adjustments, we reject companies' proposed RMA 3 and RMA 4, which reduces Pepco's revenue requirements by 2.1 million and 4.2 million respectively.
Thank you. So you'd agree that in this paragraph here, the Commission rejected Pepco's requested rate-making adjustments for post-test year reliability plant additions after the evidentiary hearings occurred.
I would agree that in this instance, in case 9418, that occurred. I would say in some of the other excerpts that we've read, pointed to at this time or the circumstances could change commission, obviously to commission discretion.
But you'd agree that the case that you cite to support post-test year, post-hearing adjustments, in that case, the Commission rejected them.
I believe what we pointed to in the footnote is post-test period.
Okay, well, appreciate the correction. And you're also aware that Pepco, the first order I handed you, the smaller one, that was the rehearing order in this proceeding. And could you confirm that in that order, the Commission denied the company's rehearing request on the rejection of these rate-making adjustments?
Can you point me to a page?
It's the page with the post-it note on it, that paragraph there.
Where we read before about the post-test year reliability spending exception, or I don't see anything on a rehearing. I might just be missing it.
So if you look on the first page of the order,
Got
the sentence at the very bottom, in its petition, just read that first sentence.
In its petition, Pepco asked the Commission to reconsider the company's positions and the Commission's decisions on 6 adjustments.
And what's the first adjustment?
Post-test year reliability plant.
Okay. And now turn to page 13 and read the last sentence of that paragraph. The first paragraph on the top.
The last sentence you said?
Yeah, the last sentence of the first paragraph.
Therefore, we affirm our decision not to grant a post-test year reliability spending exception.
Okay, thank you. So just to be clear, this the order, the case that you cited in your testimony in support of RMAs 3 and 4, the Commission denied Pepco's request to adjust the historic test year to reflect post-test year reliability plant closings.
Yes, I would say they denied 3 and 4, but I don't think that's what we quote in the footnote.
That's correct. You don't quote that in the footnote. But it's also correct that that footnote appears in the section responding to the question, do you agree with the proposed adjustment to RMA 3 and 4? Okay, that's all I have for that topic. Now I'd like to ask you about the exogenous cost regulatory asset. And is it correct that you defend this proposal in your rebuttal testimony?
Can you point me to the page on the rebuttal? But yes, I believe I do.
Page 7.
I'm there. Go ahead.
I'm just going to ask some general questions about this proposal. So to just to level set, this proposal would allow Pepco to defer recovery for minor storm expense, pension expense, and new legislative, regulatory, or accounting changes. Is that correct?
yes, it would allow a symmetrical deferral of incremental costs or an underspend, which would be returned to customers.
So, and from a rate-making perspective, could you explain how this regulatory asset would work?
Can you restate that question?
So, after this rate case is concluded, and assuming the commission were to approve this, if an exogenous cost event shows up, explain to me how that cost ultimately winds up in rates if it goes through the full process.
And specifically related to the legislative, regulatory, and accounting changes, or including the minor storm and pension? I think there's a little bit of different treatment.
Let's go with the legislative, regulatory, or accounting changes for this example.
Yeah. So I think, and it's outlined, I believe, in the testimony of company witness Lemming, that within 90 days of identifying the event, we would raise this up and communicate to the commission our intent to defer either costs or benefit associated with whatever the impact identified was. The commission would issue an accounting order to the extent they agreed or disagreed with that.
And then after the identified cost has been, assuming it's approved, it's placed into the regulatory asset, then that would be reviewed for prudence by the commission in the next rate case and then incorporated into the utilities rate base upon the commission's approval?
I would say that's generally correct. That would have to go through the prudence determination from a commission standpoint, the rate case process, the authorization, et cetera. Yes.
Okay. And so if you could turn to page 8, line 3. Now here you state that the mechanisms are designed to prevent material externally driven cost fluctuations from flowing immediately into customer bills or triggering repeated rate cases, and that the proposal aims to protect customers from interim rate increases and short-term bill impacts and pay only for the incremental costs that the commission ultimately determines to be prudent and reasonable. Is that right?
Yes.
You'd agree that under a historic test year rate, there's no possibility of an externally driven cost fluctuation flowing immediately into customer bills?
Can you restate that question?
Under a stated rate, is there a possibility of an externally driven cost fluctuation immediately flowing into customer bills?
No, I don't think there's any immediate customer bill impact.
Okay. So really, with respect to the TTYCF proposal, the customer benefit that Pepco is claiming here is the potential avoidance of successive rate increases for Pepco to recover these sorts of deferred costs. Does that sound about right?
I think I might restate it. Obviously a protection for the customer to avoid repeated rate cases, I think is what we have in here, with volatile costs that especially are outside the control of the company, that we've seen most recently in case 9655 related to minor storms and pension. I think inclusion of those costs, we're able with these mechanisms to more gradually implement those costs into rates as we come and have these rate case proceedings, and being that these would be approved mechanisms where otherwise they'd be dollar for dollar increases to the customer bill, and something that we're always considering. I think, again, I'd mentioned the symmetrical nature of these mechanisms and meant to also mitigate some of the impact on the customer, on the company, which can be a customer impact and benefit as well when you talk about credit ratings and ultimately the cost of capital that ultimately flows through to the customer.
If you could turn to page 9 of your rebuttal testimony at line 13. Here you refer to the Commission's decision to approve a regulatory asset for minor storm expense in case number 9645. Is that correct?
Yes.
Are you familiar with the Commission's reasoning for doing so?
Not the exact reasoning.
Your Honor, may I approach the witness?
Please.
So did you review those?
I'm still
you're still
taking
reading?
a look. Sorry about that.
Oh, that's okay. Take your time.
Okay.
So could you read, could you read aloud the sentence in the last paragraph, starting with the commission cautions?
The Commission cautions that regulatory asset treatment for minor storm costs is disfavored, but it is approved in this extraordinary case because of the exceptionally high dollar amounts. In order to reduce rate shock by spreading costs over a long period of time, BGE is directed to make a separate tariff filing for this rider.
So would you agree that in that case, the commission's approval of the regulatory asset was in response to specific costs that BGE had incurred prior to that proceeding?
I think, I would say yes. I think the Commission recognized the value that this regulatory asset treatment could afford to avoid what they say is reduce rate shock by spreading costs over a longer period of time.
And if you could turn back to page 9 of your rebuttal, line 17. The sentence starting storm activity, there you describe storm activity as an inherently uncertain and difficult to budget. Is that difficult to budget for? Is that correct?
Yes.
And is it correct that in this proceeding, the regulatory asset Pepco is asking for here is not driven by any prior minor storm expense costs that the company has incurred and is seeking to recover? Is that right?
Maybe not directly. I would say indirectly our experience, and I mentioned in case 9655 where we had some higher minor storm costs associated in that proceeding, I would say that could be one of the drivers in relation to this to protect customers.
But in this proceeding, there are no specific costs the company incurred that it's requesting to place into a regulatory asset, correct?
No.
Now I'd like to talk a little bit about the proposal as it applies to legislative, regulatory, or accounting changes. And at page 7, line 17 of your rebuttal, you describe Pepco's proposed regulatory assets as narrowly tailored for specific categories of exogenous costs. Is that correct?
That's what it says, yes.
And you also refer to, on line 19, certain externally driven legislative, regulatory, or accounting changes, correct?
Yes, correct.
Could you define the word certain for me as you use it in your testimony?
I think the way that I use this certain in this instance is with the experience that we have and the dynamic nature, I think that you had said earlier as well, the dynamic nature of the utility environment and what costs can be largely outside of the control of the company. I would say that's what we meant by certain. I'm certain that there will be more instances where this mechanism could be taken advantage of.
Would you agree with me that the word certain could imply a degree of clarity and definitiveness as to what is being identified?
Can you restate the question?
Would you agree with me that the word certain implies some sort of clarity or definitiveness as to what is being identified?
I think I would say that aligns with narrowly tailored regulatory assets and the fact we outline legislative, regulatory, and accounting as examples of what this could be used for.
Okay. And you're familiar with Mr. Lemming's direct testimony where he discusses Pepco's regulatory asset proposal, correct?
I am.
Are you aware that he does not use the word certain or narrowly tailored in his introduction and discussion of his proposal?
I'm not specifically aware of that, no.
Subject to check, would you accept that the words certain or narrowly defined do not appear in that at any point in that section of his testimony?
Subject to check, although I think we're aligned in, I know we're aligned in what these mechanisms are meant for and how they're meant to be utilized or how they can be utilized, especially from a customer protection and affordability standpoint.
We'll get to your alignment with Mr. Lemming in a sec. And you're generally aware of how Mr. Lemming presents this proposal in his testimony, is that right?
Yes.
So you'd agree that for legislative, regulatory, or public policy requirements, he identifies, I think it's two sort of kind of
examples,
two criteria that need to be satisfied. The first would be these requirements must be new and they emerge after the filing and approval of Pepco's rates.
Can you point me to his testimony where it says that?
Yeah, page 12, line 20.
Of which? Of
Lemming's direct, part 2.
Maybe up here. Is it going to be in this one?
Is that part 1?
There's a lot
That's
of
the
testimony.
rebuttal.
Yeah.
Got it. Counsel, is Connor going to need the rebuttal binder because he's running out of room up here?
Yeah, I won't ask any questions about the rebuttal.
You can put it up here. I can see it.
You're the only one who could.
What page? Sorry.
Page 12, line 20.
Are we in part 1 or part 2?
Part 2, sir.
12, line 20.
That's correct, yes. So I think that was the cites to the prior version. The testimony that Pepco filed, this would be on page 6. I had the site wrong. My apologies.
What was the line number?
Let's do line 2. And this, yeah, lines 2 through 6.
I might not be at the right place. I'm looking at the revenue requirement drivers and please summarize the contents. You said page 6?
Is that part 2 you're looking at?
I'm looking at part 2, Counselor. Direct testimony, part 2, the TTYCF only version. Should be the question stating, is the company requesting that this regulatory asset liability treatment be allowed to address any other exogenous costs?
Yeah, I was on 12 before, so I was good with where you were before.
Okay. That's on 12. So,
Okay. So if you could review, starting from line 12. You'd agree here that Mr. Lemming kind of explains the basis for which a cost would be eligible for inclusion in this regulatory asset. The requirement, like the policy or legislative or regulatory change, it would have to be a new change that would occur after the company's rate case application is approved. And it would have to have an impact on the company's cost of service. Does that sound right?
I'm on line 21. It says, have an impact on the company's cost of service and emerge after the filing.
Okay, thank you. And were you present for Mr. Lemming's cross-examination on Monday?
I was.
Do you recall that Mr. Lemming and I discussed whether Pepco's proposal contains any limiting principles or guidelines on how the company would determine what costs it considers eligible for the regulatory asset?
I was here. I vaguely remember that conversation. I'm not sure if I remember it verbatim.
Do you recall that Mr. Lemming stated that the proposal does not contain such principles or guidelines?
I don't know that it states principles or guidelines anywhere.
But just in the discussion, to the best of your memory,
Okay.
from my cross-examination with Mr. Lemming on Monday, do you recall if him confirming that the company's proposal does not contain limiting principles or guidelines?
Subject to check.
Okay, thank you. Do you recall that Mr. Lemming acknowledged that there are numerous commission orders issued each year and new legislation passed each year that could impact the company's cost of service?
Yes, I remember him saying that.
Do you recall Mr. Lemming acknowledging that the company would be able to request a regulatory asset or liability resulting from any or all commission orders issued or new legislation enacted that the company determines impacts its cost of service?
I think his response was, yes, he acknowledged that we have the ability to request regulatory asset, but the purpose behind this is to gain some administrative efficiency by the means of which we do that.
But the company would have basically, if it determines a regulatory change impacts its cost of service, the company would be able to propose it. Is that propose treatment as a regulatory asset for that cost?
Generally, I agree with that.
So if you could go back to your testimony, your rebuttal testimony, can you identify any criteria described in your testimony that the company would apply to determine? Or I'll wait till you're there.
Any specific line in my rebuttal?
No, just generally in your rebuttal. The section where you discuss the exogenous cost regulatory asset, preferably.
Sorry, can you repeat the question?
So in your testimony, can you point me to or identify any criteria that you describe which the company would apply to determine whether a new regulatory, legislative, or policy requirement would affect the company's cost of service?
I think on lines 5 and 6, I talk about material and externally driven cost fluctuations. Not sure if I'm understanding your question.
So my question is, So your point to materially or externally driven cost fluctuations. So is that the criteria by which the company would determine whether its cost of service is impacted by a regulatory or policy change?
It's not the exact wording, but I think it's meant in a similar fashion to describe impacts to the company's cost of service. I don't think we would, we try and define that here as material. And then externally driven, I think, sort of aligns to legislation to the extent that that is largely out of the control of the company.
And that let's focus on legislation for a sec. So that would that include only changes to the public utilities article that directly affects how the company's regulated, or could that be any legislation that's passed at Annapolis to the extent it impacts the company's cost of service?
We do not provide a definition here of that.
Okay, thank you. So your testimony is consistent with Mr. Lemming's then, that effectively any change in law or any new regulatory requirement that affects the company's costs in some way could be eligible for inclusion in a regulatory asset under the company's proposal.
I would say potentially, but the discretion remains with the commission.
Does Pepco know how many legislative, regulatory, or policy requirements may impact the company's cost of service in any given year?
I'm not aware.
And Pepco can't forecast or plan for changes in regulatory, legislative, or policy requirements?
I would say these are largely meant to capture events that are outside of the control of the company. So I don't know that we couldn't forecast for them to the extent that this is a traditional test year, but
so you'd agree with me that there's a large degree of uncertainty about the types of policy and regulatory driven costs that could be eligible for regulatory asset treatment. Is that right?
we do not define specifically the population of events that could occur or could be managed here.
So you'd agree that the extent of policy or regulatory driven costs is at this point to the company is uncertain.
Objection. I think that's just been asked and answered.
No, I'll allow it in this instance, overruled.
Can you ask your question again?
Sure. So you'd agree that there is a large degree, from the company's perspective, the types of policy and regulatory-driven costs that would be eligible for regulatory asset treatment, the universe of costs is uncertain right now. The company can't anticipate what changes in Annapolis might happen.
There is no clear definition of exactly what would fall under this category.
So you'd agree that it's not certain?
Objection asked and answered.
In this case, sustained.
So given our discussion today, do you still maintain that the costs eligible for inclusion in a regulatory asset for new legislative policy or regulatory requirements are certain and that the proposal is narrowly tailored?
I would agree that they are still certain, that legislation will occur, that regulatory environment will shift, and that there will be impacts to the cost of service. What was the second part? Sorry.
Do you agree that the proposal is narrowly tailored still?
I think we've provided at least some guidance here of what we mean by narrowly tailored with the legislative, regulatory, and accounting changes.
So it's your testimony that potentially any legislative, regulatory, or policy change that could be the possibility that any regulatory, accounting, or policy change could be eligible for regulatory asset treatment.
Your Honor,
That's narrowly tailored.
Your Honor, I'm going to object. I think we've already been over this. He's asked this question at least once or twice before.
Yeah, sustained.
Appreciate your time today. Thank you. No further questions.
Who's next then? Okay, MEA in this instance.
Yes, hi, thank you.
Actually, I'm sorry, Your Honor, just before we move on to the next party, just a preliminary matter. I do have the mail log numbers that staff was asking for. For Mr. Nelson's testimony. Do you want me to read those out now, or do you want to wait until we're done for the day?
Let's wait until we're done.
Okay.
Or you could just, does it have to be verbally communicated before the bench? Okay, all right. Okay, we'll do it, we'll put it in the record later. Okay. MEA, good, you're up.
Okay. Thank you. Hello, Mr. Nelson. How are you?
Good, how are you?
During MEA's cross-examination of Part 2 of Pepco witness Lemming's testimony, when we asked him to specify Pepco's total capital expenditures costs for certain investments, including White Flint, Mr. Lemming indicated that you were the best Pepco witness to provide this information. And so I have some questions for you. And, you know, to provide context, we are trying to associate the ITN numbers for certain investments for which Mr. Lemming's testimony, his rebuttal schedule, Part 2 schedule RTL-2-R-3 has some amounts, and we want to reconcile, especially given the late change between the forward-looking test year and the traditional test year, how that reconciles to the investments currently being sought in this case, you know, based on a traditional test year, and to associate the revenue requirements that are being sought associated with those investments. So, with that, could you please state for the record the total cost of Pepco's investment for White Flint in this case?
You're talking plan additions as well, right?
Total plan additions.
Okay. Can you give me some ITNs to reference that I can?
Sure. 74120, 74121, 74118, 72002, 72200, 73657,
Yes. Would you like me to
Yeah.
read them off? Yeah. So I've taken some notes as we've gone through this. 74118, and this is plant closings within the test period that are being sought for recovery. So it covers the period of April 24 through September 2025. The plan additions for 74118 are approximately $2 million. 74120 is 114,500,000 approximately. 74121 is 48.4 million, so 48,400,000. These are approximate numbers. And that is everything within the test period.
Okay. So the 2 million, it's not the total plant investment for 74118, right?
This is what closes in the test period.
What closes in the test period. Do you know what the total amount of the investment for 74118 has been?
I do not have that number offhand. No, I do not.
Who would have that number? Or where can I find it?
I would say from a discovery standpoint, I think we had provided data along the way around capital investments, specifically tracing the capital expenditures that have been built into plant in service within the test period. To the extent that plant hasn't closed into service, I'd say that there was an opportunity for discovery of that as well.
So you use the word plant closings versus plant additions that was used in the schedule, Mr. Lemming's schedule to his rebuttal.
I'm using them synonymously.
They're synonymous?
Apologies if I added confusion.
Okay. So where can, in the record, can we find the numbers you have just informed me about?
I would say currently in the record, RTL R-3, which you've referenced. I think outside of that, the parties have all been at some point communicated with the discovery for plan additions in the period, which is RTL R3 covers April 2024 through December 2024. There were data requests submitted to the company, which we responded to, I believe staff 40-10, where we provided all plan additions for the period of January 2025 through September of 2025 that parties have relied upon for the basis of their analyses and their revenue requirements in this proceeding.
Okay. And do you know the revenue requirement associated with these investments that you are seeking now in this case?
I have not done the math. I will say what I've referenced here are terminal plant additions. They would need, obviously they've gone into service in different months within the test period, so their 13-month average could vary.
Is there a document that's been filed in the record that I can look at to determine that amount?
I would say from the record standpoint, and being that we've now pivoted to a traditional test year from a push there from a legislative standpoint, what is being requested recovery of is the plant balance as of September 30th, 2025. So that sort of supports the record of what investments add up to our plant balance included in our revenue requirement. I think it's CN1.
And so those plant balance amounts, just for my clarity, are the numbers you explained to me, the 2 million, the approximate 114,500,000, and the 48.4 million for White Flint.
They are inherent in that September 30th, 2025 balance.
Mm-hmm.
It represents actual plant additions or plant balance.
Okay, thank you. And in none of your testimony or exhibits, supplemental, you filed a lot in this proceeding. We won't be able to tie ITN numbers to any document that you have filed for all of these investments.
I don't know what the full record constitutes right now. I would say I'm not aware of any exhaustive project list that sits out there.
Nothing in your
Nothing in my
nothing you
testimony.
sponsored.
Correct.
Okay. How much total capital expenditure is Pepco seeking to recover in this case now?
You mean plant additions, I assume, right? Just to make sure we're clear, I think there's been a lot of conflation with some of the back and forth in these hearings about what's capital expenditures and what's capital additions. Capital additions is what's being sought that actually gets into rate base and is being sought for recovery here. I don't have that exact number within my testimony. I will say there's a portion of that in RTL R3, and then the other portion would have been submitted in discovery to the parties as they requested the plan additions that are closing within the period of January 25 through September 25.
And you said parties have a different understanding of plant additions versus capital expenditures. Can you tell me your definition of capital expenditure?
Capital expenditures are dollars that are being incurred and are not yet used and useful, providing benefits to customers. Finally, when they are energized and placed into service, that constitutes a plant addition, is when they are added to rate base.
Okay, thank you. And turning to the revenue requirement, what is the traditional test year revenue requirement that Pepco originally sought in this proceeding?
I would need to look at my direct testimony. In direct, it was $142 million.
And what is it currently?
I believe in surrebuttal it was 119.9.
Can you repeat that for me?
119.9 million.
Thank you.
I'm gonna double check that.
Okay. And the withdrawal of the fully forecasted test year, did that have any impact on the traditional test year revenue requirement changes or anything that you're trying to seek now? The 119.9?
No, those changes were not as a direct result of the withdrawal of the FFTY proposal.
I also have some other investments I want to ask if you could tell me what the amount that Pepco is seeking recovery of at this time. Can I give you ITN numbers?
Sure.
83122. That's for community solar automation. SAP. And then 79264, which is the end use customer flight path.
Those two.
I have two more, but first we can start with those.
For 83122, that has approximately $1.9 million of closings in the period of April 2024 through September 2025. 79264 has approximately $800,000 of closings in that same period.
So you are seeking that in this case currently. You're seeking to recover that.
Yes.
To confirm. Okay. I am a bit confused because we understood from company witness Vospic that Pepco was not seeking a recovery of that. So
I think there may have been just a little, and can understand how it might be a little bit confusing with some of the plant schedules. The pieces, really, the basis of the plan additions were RTL R3. Segments based on the witnesses were extracted from that and placed into the witness testimonies for the responsible plan additions that they owned in these categories. But this only covered plan additions over $1 million. And so to the extent that they did not have plan additions over $1 million in the one line, it may have had zero. And so that may have been a little bit of the confusion that exists within that specific table. I will reiterate that, I think through discovery, parties have requested the dollars of under $1 million as well. And so I think we've provided the basis not only for April 24 through December 24 and what is in RTL R3, but the period of January through September of 2025 has been provided to the parties as well.
So for ease or convenience, is there one place that has all the ITN numbers and whether it's over or under $1 million, and if it's being sought, that we can refer to know where we are in the case currently and what is being sought?
Yeah. Not that I'm aware of currently. As I said, there's a couple different places. I would say that the company's sort of been pushed into this circumstance with the legislation where our original proposal was the FFTY, and we had dollar amounts that were actual for the period of April through December of 24 and then projected past that point. Those dollars have since, are not being sought in that same format. And so the parties were able to provide, or were afforded the opportunity to issue discovery to the company, which we were responsive to. And I think every party has provided, or generally every party has provided, a revenue requirement based on the information we've provided.
I also want to ask you about whether Pepco is still seeking recovery of two more ITN numbers, please.
Sure.
ITN 61876, which is the ADMS, Advanced Distribution Management System implementation, and ITN 62068, Geographic Information System.
So for 61976, I have approximately $200,000 within the test period.
I want to confirm we have the same numbers. 61876, ADMS.
Yeah, so for the ADMS project, I'll say it has approximately $200,000. For the GIS project, there are no plan additions within the test period.
Okay. And I need to turn back because I just got notice of the bench request response that Commissioner Suchman requested, and I'm seeing a $0 value for 74120. Bear with me, I just received this, so I'm going to pull that up. I don't know if you have it even. I don't have copies of it, but it is a cause of confusion. I don't have it. 1 second. I don't know if the council has that.
I don't have a copy with me, no.
I'm afraid I need to ask for clarification to ensure we have what numbers we need, to understand MEA's position in turn. But let me pull that up. I'm sorry I cannot put it before you.
I haven't been served the response to the bench request. No, I see it right here. I mean,
And again, maybe it has something to do with nomenclature, but it's the bench request MD 9820 AOBA DR2-9G update attachment, page 1 of 2. It says carry forward capital expenditures for ITNs in schedule RTL-3 and for in the millions or in the ITN description, the 2024.
This is capital expenditures.
Okay.
served to us.
I'll just finish.
I think there were a couple different bench data requests. It's not here. Yeah.
Okay, because when I saw 74120 White Flint 2024 ending balance 0, I just wanted to ensure.
They were on two different pages, and we just asked that they be put together. So that's what this is. So this doesn't add anything new.
For my benefit, maybe I'm not following or I'm slow on this uptake. I just want to make sure that the 0 here is not related to what you've just said. So that doesn't change anything. The numbers are still what you explained to me earlier today.
Yes, I think this is a little bit more of a difference between capital expenditures and what is not yet used and useful versus what has been placed into services and is providing benefits to customers.
Okay.
Which I think was maybe Commissioner Suchman's second data bench request.
The reason for the further confusion was because the next project listed in this response, 74121 for White Flint sub-construction new supply lines, did have a $44,496,000 amount. So I was wondering why the top number was 0 and then that one was there.
Council,
So
would you mind showing me what you're looking at?
yeah, sure. I mean, it just came through.
This was just filed today.
This is your, I'm trying to
Sorry,
pull
can you
up.
scroll up so I can see when
I
Was
know.
this response provided by?
This was when it was on two different pages, and the chair asked that they be put together in one.
Right, I asked that it be put into one Excel spreadsheet so we could see what the,
This doesn't add anything. This is just making it easier to read.
Understood, Your Honor. It's just if council wants to ask the witness any questions about this, I want to make sure the witness has a copy, so we can try and pull it
I
up
can
on
see
the
it.
laptop. You
Yeah,
have it?
mine.
Okay, good.
Assuming we're looking at the same.
Thank you.
Thank you, everyone. Yeah, so if the numbers you've given me are the right numbers and any confusion I may have about this exhibit, the bench request response, we can be sure we can rely on the numbers you've given me today.
Yes, and I think you'll see those same numbers in the bench data request.
Okay.
Not the one we're talking about right now, the subsequent bench data request.
Bear with me a moment. I just. That's all I have. Thank you.
Ms. Francis, how much do you have?
More than 60 questions?
No, no, but I'm kind of tired. If I have a choice, I'll go tomorrow. It could be a half hour at least, 30, 40 minutes.
All right. In that case, I think what I'm going to do is I'm going to have us quit for today. Tomorrow we will start at 10, and tomorrow is probably going to be a very long day, longer than today. So, the mail logs. Let's get those mail log numbers into the.
Absolutely, Your Honor.
As telling me to write it down.
As I mentioned before, for all the witnesses, we're using the clean versions that were filed on April the 24th. That is mail log number 329413. However, there were no changes made to witness Nelson's testimony, to any of them. His direct testimony was filed under mail log number 323275 on October the 14th of last year. His supplemental direct testimony was filed under mail log number 325456 on December the 18th last year. His rebuttal testimony was filed under mail log number 327809 from March 11th of this year, and the surrebuttal testimony was filed under mail log number 329083 on April 16th of this year.
So is the only one.
Ms. Herman, is that everything?
Yes, thank you very much.
Okay. In that case, anything else?
No, I was just going to ask, was the only one that they're using the new clean version, the one that was filed
I can't hear you. I'm having difficulty hearing you.
Was the only one that you're using a different version than I am, or you're using the clean version, 323275, the first document?
We're using the clean on April the 24th under 329413 when we filed the clean in the red lines. We refiled all of Mr. Nelson's testimonies.
If council could just tell us, the mail log numbers you read, are those the ones that we should look at? We want to know what document to look at, and I'm so sorry to impose. I can ask this tomorrow. We can start tomorrow with it. Okay,
let's get
perfect.
this cleaned up right now.
What ML number should we look at, sir, when we're reviewing the case?
329413. Those are the ones that we've been entering into, at least for this witness. Those are the ones you should be looking at.
Okay, thank you.
You're welcome.
Are we good?
Yes, sir. Thank you.
In that case, we're done. See you tomorrow morning.